call the special meeting of the Calaveras County Planning Commission to order. We get started with the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And are there any staff announcements or agenda changes today?
None, Madam Chair. Thank you.
And we have no consent agenda items or regular agenda items, so we will move on to our informational item, the continued discussion of the comprehensive update to the county zoning ordinance. And we're welcoming everybody who's going to provide a little background for us on the potential of building single-family residences within the timber preserve zone.
Yeah.
So we want to get all of your input on that.
So we have lots of guests today.
Yes.
So you know Doug Oliver, he's our chief building official. We also have our new fire marshal for Calaveras County, Dominic Ramos. We have our Calaveras County fire inspector, Michael Clark. In addition, we have the presence of Mike Johnson, which is a fire chief for Ebbets Pass Fire District. So we've got lots of input today.
Yeah, so we had quite a discussion at our last meeting about the wisdom of allowing single-family development, which would be a single home, potentially ADU and any other accessory buildings within the timber preserve zone, given that there's little infrastructure out there and access might be more difficult. So we'd love to hear from you guys if you have an opinion on that. And Doug, I know you have an opinion.
I got all kinds of opinions. I'm going to rely on a lot of
Okay,
local expertise in that.
come on up.
And I think also it's the question of if we allow single-family residence, just what else necessarily has to be approved? I mean, it is included in that approval under state law.
Right, so that under state law, any place that is allowed to have a single-family residence would be allowed to have transitional housing or supportive housing by right with no further review. But it appears that it would be limited in scope by their license and the size of the facility. So theoretically, it has no more impact than a single-family residence, but that's part of our concern. And then we have the option to not allow development, to allow development by right, or to allow development with an AUP, a CUP, or with some predetermined conditions. And we've been sort of headed toward a middle ground, but we're here to learn.
Okay. Doug Oliver, Chief Building Official. What I'd like to do is kind of give you the building department perspective on it and just kind of skip a rock across the fire stuff and then let the fire experts come up and talk to you about that. As it pertains to single-family dwellings, first I want to highlight that we do have a housing crisis in California. So any way we can do to get some reasonable housing, my recommendation is we should explore that. That being said, there's a good point. There's a lack of infrastructure. There's long response times due to proximity to fire protection, and roadways are a concern. A residence in the building code as an R3 occupancy can be used for other minor uses that are similar, which normally fall into what's called an R3.1, or in some cases there's exceptions, essentially where you have a limited amount of people in the home performing similar uses, So for instance, what we would call a bed and breakfast, you're allowed to have a transient lodging scenario where it's 5 or fewer sleeping units and the owner is living in the building. And so they're considering that similar to a residence. As far as the construction of the building is concerned, it also, some of the fire protection measures is similar. However, we know that it does generate additional traffic. It does generate additional parking issues, driveway issues. So we could have a consideration that, anything that's beyond the use of a single-family dwelling or an accessory dwelling unit would affect the ability to provide fire protection or any type of emergency services to those locations. Anything beyond that, though, triggers a different occupancy type, which typically triggers what we would call a code analysis and a tenant improvement. So the moment you take a residence, you turn into residential care facility where you've got, let me just throw out a number, 15 people and non-ambulatory patients. You don't have a different occupancy type triggering commercial standards, triggering commercial roadways, triggering a lot of things that once again, I'm skipping a rock across the top of what happens when you change a residence into another use. There's a lot that building code and regulations from the Board of Forestry, fire code, these would all be triggered and cause a significant change to how that property is used and developed. So that just my high, 30,000 foot notes on that. I think it'd probably be more appropriate to have one of our fire personnel talk about how that change would impact their ability to provide services or the fire codes that are in play.
So let me be clear, in this case, though, the state is telling us that for supportive and transitional housing, we cannot have any additional requirements that we would not have for a single family residence.
I just want to, I'm not sure that my analysis for the planning commission was for the discretionary approvals. I don't know the answer as I sit here, whether it actually affects what the building official would require from an occupancy standpoint. In other words, if we have to allow a residential care facility to the same extent as we would allow a single family residence when it comes to zoning, I don't know that that actually changes what Mr. Oliver would have to do in terms of different types of occupancy. So I don't know the answer to
I think unless the number of occupants exceeds it, it's going to be the same thing, because we allow people to do that now. As long as it falls within that small group home sort of situation.
So am I understanding this correctly?
But that's not what we're addressing here today anyway. I mean, we can't tell the building code what to have in it.
Madam Chair, go ahead.
I need to have it made clear to me, if we allow a single-family residence on this type of land, are we necessarily including in that that there can be a small residential care facility? Assuming that it's.
Yes, I mean, from a zoning standpoint, the housing laws as Martha, is Martha Miller here today?
Well, we're having difficulty getting her on as a panelist for some reason, so she and Annette are working on it, but.
Yeah.
So the issue was, I don't know how, if it's been explained to you, Mr. Oliver, the issue is that the housing laws tell us, at least in the planning department and planning commission, the zoning, that to the extent we allow a single family residence anywhere, we have to automatically allow 3 types of protected housing, like a residential care facility. I forgot the transitional housing. It doesn't speak, the parts I read didn't speak to the maximum occupancy or anything like that. It's just that we can't add any steps to allow those. If we allow a house, we have to also allow these other things.
Right.
Yeah.
So my understanding of, and we could do a deeper dive on this later, my understanding of these housing regulations is unless they're specific as to what code, building codes or other regulations they're setting aside, it does apply to the zoning, but doesn't change our process. So for instance, in the regulation or the legislation that came out for ADUs, it specifically addressed that if the home on the parcel does not have fire sprinklers and you put an accessory dwelling unit on the parcel, it is exempt from sprinklers. That is a specific waiving of a code requirement in the building code. Other than that, the rest of our reviews, the rest of our procedures are still in effect, in addition to the 4290 regulations for defensible space and driveways, the basic requirements for ingress and egress. We still follow all those regulations because they aren't specifically addressed. So
Those are in the state law?
yes, the Board of Forestry's regulations would be triggered whenever there's a new structure. However, there are specific exemptions that, I'll just say this, accessory dwelling units have gotten a wide path in order to try and grow housing. So it is possible that some items are set aside because the legislation says these individual components of building code, fire code, Board of Forestry regulations, these are set aside for ADUs. Nothing that I'm aware of has come out that limits our enforcement of code for any residential care facilities, any family daycare, any of that stuff. So whenever you trigger those components in the building code, we're going to enforce to that standard.
Here's the rub on it, though. You might not know that's what's getting built. They can come in, build a single-family residence and convert it without coming back to, at least to zoning. So unless they're making physical changes to the structure, it's not going to come back to you either.
There's one mechanism for that, and that's the business license process. Every new business that has a structure they're occupying in the county does route to building, and we do review those for compliance with building code. We're not going to grant a business license for something that we have to change the use and occupancy of the building until such time as we've done that tenant improvement.
I think we need to look into this
also-
because I think
well-
very clearly the intent is not to impose additional requirements above and beyond what a single-family residence has. That doesn't mean that if they need to modify their bathrooms or, do something that they don't have to come get a building permit, at which point you're going to apply whatever.
No,
But-
I see your
Yeah.
point. I think
But at the point that so we have an existing residence and there's a proposed conversion to a small residential care facility, through their state licensing
Yes,
process, doesn't the building department get some sort of a notice of that license for that facility? How do you?
it typically
How do you
triggers a
get-
fire.
now,
It
how do
typically
you-
triggers a fire inspection.
Yeah.
But in addition to that, I would say this. I see your point. I would argue that if it says no additional restrictions, these codes have been on the books for a long time. They're not additional. They're a function of our review process whenever an occupancy
Additional
changes.
restrictions above and beyond what you apply to a
Right.
residence. I'm not talking about new restrictions. I'm just saying that seems to be the direction they're going in. And I think it's to your earlier point that we need housing. We need housing for groups that sometimes the neighbors complain about. And this is not just in this zone. This is across the board, this situation. It just came up in this zone because we saw it as, what if their license allowed them to have many more people than we felt might be prudent to have in a place that it's harder to get people out of and evacuated. So, I think realistically, for some of those uses, you might need to make modifications anyway. So you are going to get an opportunity to see it.
Yeah, and as part of the state licensing model, they ask for the local inspections. So we are going to see them. If they sneak by, then we eventually get a complaint and it becomes a code compliance issue, and we encourage them to comply with all of those other requirements. So there's at least three
You're going to have
paths.
exiting.
Yeah, you're gonna have at least three paths to compliance with the appropriate standards.
Mr. Oliver, one of the other issues mentioned at the last meeting was safety. we had somebody online who emphasized to us that the TPC zone is very, very prone to fire hazards, and questioned the reasoning behind allowing residential uses on those properties, even to the extent to which the state needs housing. So, and that's one of the reasons why I think you're here, and the fire marshal and the Ebbets Pass fire chief are here, is what are the risks of allowing a single-family residential zone, or single-family residential dwelling or a group home in a TPZ zone, knowing, based on our current code, how the TPZ zone functions? I mean, is that a reasonable concept to allow residential, or is it like, it's too dangerous, we don't have response time, the driveways and the width of the road and all those kinds of issues? Can you address that, or can?
Yeah, I think it would be better, yeah. I make the process happen. I step out of the way.
I see him getting up.
He is probably all of our expert, and he certainly is my expert in all things building department. So please keep in mind that, Doug's value is significant to all of you, and really to me too. But to speak to your comment, is you're absolutely right. So in that, I think you started with a broad paint stroke with where's the wildfire severity zones that the state recently updated, right? And I think that you'll see that the areas that you're talking about are in the severe, right?
Yes.
And that even goes lower than it did previously. So I think anytime we're talking about adding care homes and things like that, that should be taken into consideration. And the other piece is that in Ebbets Pass, it's not just wildfire, even though wildfire is the highest threat to our community, but it's also snow, right? So overcoming snow, and snow sometimes loads trees, and trees sometimes fall into power lines and across roadways, and snow plows can't clear that until the PG&E folks come, or the utilities, and remove that. So even when you're healthy, strong, and able-bodied, it's still more difficult than in an area that doesn't have those things, right? So on top of that, with our topography and how we build homes up in the mountains, it's called the mountains for a reason, right? So we build them on the side of a hill. They have 2, 3, 4 flights of stairs, none of those which I believe would be ever considered to be ADA compliant unless we start adding things like elevators and things like that. And you're right, in a rural service community like ours, we're not a big city, and we are limited about how many resources we have.
So,
Yes.
so if our hands are tied by state regulations, and we must allow this, what are some of the anticipated conditions that you would recommend at the very minimum, that if you were going to do this, please make sure A, B, C, D, E?
Well, I think as a county-wide group is your oversight, and of course Doug's ability. You have the ability to address things through county code. When local fire districts like mine, we address this. We do it through our fire ordinance, and of course the smaller point of the pin as far as a district goes, we probably have more flexibility than the county, and so on and so forth. But I think if you're gleaming from just a reasonable expectation that say, hey, in order to get the business license or to pass our inspection, you have to be ADA compliant, you have to maybe the severity zones that are something that we don't regulate anyway, that says, hey, the state severity zones dictate that this is a high threat area for wildfire. We don't want to put people in harm's way that may not be ambulatory or have special needs to get out of here. That could be something too.
So most of these people, it's not that they have physical disabilities for the kinds of housing we're talking about.
Okay.
It's not medical. It's usually, it's transitional or supportive housing. So they're people who may have had some kind of substance abuse problem, or
I got you.
it could be all sorts of things.
Right.
The likelihood that anyone's going to run a business from in a timber preserve zone of that type seems pretty slim to me in the first place, but it's still something we have to be aware of, right? So
Sure.
even thinking of it as a home, a single-family home, you know, out in that area, it seems like we have kind of the same risks, just magnified a tad by the fact that someone's paying for the opportunity to be out there.
I got you. Well, in that case, I was going in a different direction, right? So
Yeah.
I'm thinking folks that need help getting in and out on a good day. And
Right, it
then we're,
doesn't mean that, but you
right.
could have someone in a single-family home.
Right.
Who had some kind of a disability, and you could have somebody with
Right.
some sort of ambulatory problem.
Yep, I think as long as you address all those challenges, however you get them addressed, then I think you check the boxes. It just has to be a process and to ensure that we check the boxes.
Chief, did you speak to, we've been talking about the risks to the people in the houses. What about the risks to the firefighters? And what sort of psychology do the firefighters face if they know the residence, say, that's on fire is in 3/4 of a mile in a severe fire zone? How does that enter into your operations, and how should we consider that? And should we consider that when we're dealing with this subject?
Yeah, I think when we're talking about a remote area that's way out, brand new place that's brand new for the development and your commission to look at, you know, obviously 4290, the forestry, the state forestry guidelines has a pretty robust guideline on width of driveways, how long, how many feet we should be away from fire hydrants, how many turnarounds. So I feel comfortable that at least the access part for any new development right now would meet that criteria, should benefit our local fire agencies.
It's gonna be a single-family driveway.
Single-family driveway, yeah.
Yeah, so
And Doug knows
those
more about,
requirements,
off the top of
yeah.
his head, what that would be, but I mean,
14 feet
certain.
wide.
Right.
Whatever the clearance, yeah.
And, you know, they're gonna have to meet all those same guidelines.
So
Doug, you
I
wanna talk
think
about
one
that? Yeah, I
of the
think we- I
things
think we
we
can answer
were,
that. Yeah.
we were questioning is, what, if we were to say that we were going to allow it, are there conditions that we could apply that we think would be universally beneficial because of this remote area? So what would you recommend, or would you recommend something above and beyond what is already
The
required?
minimums.
Okay, well, I guess I'll break it down this way. I think first that we need to understand with county council how this prohibition from anything, you know, more restrictive than a residence, how is that applied to the Board of Forestry's regulations? How is that applied to building code, fire code first? And before I can make that recommendation, because if it turns out that this is only restricting zoning from being able to apply new regulations, then the current framework we have should be sufficient, because the moment you go over 5 occupants, the moment you go to non-ambulatory, the moment you go to anything that triggers anything beyond an R3.1, the building code, fire code, and the Board of Forestry regs are triggered, and now you need a 20-foot wide driveway. Now you need a commercial encroachment. Now so our current framework would work if the new legislation would exempt them from that, then I would call that a significant risk. And
So
I think,
what we can do right now is, regardless of whether it allows that, we could require even a single-family residence because of the possibility of it being converted to incorporate those things from the beginning. So any development in the TPZ zone, which would be limited to a single-family residence and the accessories physically, the accessory
you
buildings
could,
and an
you could.
ADU. So, you know, would it be beneficial to look at putting in a more significant access road, having greater water storage, because their likelihood of having a fire hydrant is gonna be pretty small.
my only concern is, well, how do I? You could make those recommendations.
Because
but-
isn't the risk and the difficulty of accessing them the same, whether it's a family out there, which could be a large family?
We would have to be careful though, because there's a, I mean, I lean on there's a need for housing, but there's also a requirement that we don't, by the implementation of new requirements, we don't take the homeowner or the property owner's ability to use their
It's a
property.
timber preserve zone. They don't actually have the right to have a house in it
Well, I
unless
mean,
we give it to them right now.
I would recommend that we either ban it or we allow it because of the codes we have in place. I don't know if I would allow it, but add enough regulation to it beyond what we already have that would make that use unlikely because of the cost. So I would say that in timber preserve, it may be more beneficial to say yes or no rather than yes with all these additional restrictions. That's a recommendation.
That's their decision to make, but
Can I ask you a question?
sure.
We should explain who this voice from
Yeah.
above is.
Oh, hi, Tom Infacino, Calaveras Planning Coalition. This is a really good discussion, first of all, I want to say. And this is my question, and I don't care if Doug answers it or Julie answers it or whoever. When you look at the actual government code section 65583 subdivision C3, which is what we're talking about, it talks about what transitional housing and supportive housing in the context of a housing element. And the beginning of it, the first sentence is address and where appropriate and legally possible. And then it lists a bunch of things, and among those are transitional housing and supportive housing shall be considered a residential use of property and shall be subject to only those restrictions that apply to other residential dwellings of the same type in the same zone. And that says supportive housing, as defined by section 65650, shall be a use by right in all zones where multifamily and mixed uses are permitted. So, now, given that it says where appropriate and legally possible, in the TPZ, among the compatible uses in the TPZ are, quote, a residence or other structure necessary for the management of land zoned as timberland production. I emphasize the word necessary. And I guess my question is a group home necessary for the management of land zoned as timberland production? It seems to me if it's not necessary, it doesn't have to be allowed because it's not legally possible in this TPZ as defined by. Now, so if I think we can reconcile both the housing law and the TPZ law by recognizing that group homes are not necessary in the TPZ, and therefore they are not legally possible in the TPZ, and therefore they're not required. That's my take on it. I'm happy to hear Doug's or the fire department's or Julie's or anybody else's.
They're not really the right.
Okay.
That's really a Julie thing. It
Okay.
probably.
I think it's both. I have an
sort of see
idea.
it also,
Doug
but-
has an idea.
Yeah.
Well, I would say based on that language first, government code, if I'm not mistaken, and we can dig into it deeper, if it says that this shall be considered a residential use, it doesn't say what codes we're interpreting. So that means, in my mind, it would be all of them. We'd have to consider, now, but that also means we're restricted to only residential use consistent with the management of that timber production, which means if we allow a home under timber production, it can't be converted to anything else. And if they stop timber production and change, and this is where I'm going to be dangerous and act like a planner for just a moment. Mm-hmm. In my mind, it would suggest that if it was allowed in conjunction with the timber production and they stop timber production, that becomes an existing non-conforming use that can't be turned into anything else. Would that be correct?
I don't, I think we would need to take an
Yes.
independent look
Mm-hmm.
at the housing code. I can't necessarily, I don't have it
Yeah.
memorized. And so I
And
guess
there's
the question
always-
I have for the commission is your decision on this hinging on the potential for these other types of housing to be built? Is that what, is your decision going to be hinged on
Right.
that? Or is it going to be an independent policy decision that doesn't? I mean, I'm happy to research it if it matters to the decision you make about whether to allow SFRs by right or by use permit in the TPZ zone.
Well, I mean, let me complicate the issue
good.
a little bit more. So let's say that in order to harvest the timber, there is a home built and has several people living in it, you know, just like a farm worker, quote unquote, type of a situation. Now, and that goes on in perpetuity. So, you know, they're there to harvest the timber, they're there to, you know, do whatever other kind of fire management things that are necessary. Now you've established a home that is, by definition, a group home, but still a single-family residential. Do you see where this is going? So I think by what we're trying to allow or not allow is so, the lines are so blurred that I could come and say, okay, I own this property, I need 15 people to service all the timber on the property. I've now established a legal group home of sorts or a farm worker home. And those actually have more protection on them than, you know, your typical type of residential uses.
I don't think
What-
that type of housing, though, would be is equivalent to a single-family residence.
It can be.
Mark-
It can be.
So this is where I say what I've,
Employee housing?
Not,
that- to-
but
well-
employee housing implies multifamily, and I think what Doug is gonna say, this could be a single-family home where people are just using separate bedrooms.
so what I was gonna say is it's something that I'm becoming famous for with my staff, and that the answer is that depends. Because
You
there's,
sound like a lawyer.
yeah,
You should
So-
read my website, that's what it says everywhere.
yeah, that
depends.
that
The answer
depends.
is-
Because how many people are in that building before it becomes multifamily housing as opposed to a congregate residence, which can be a dwelling? So I would say this, anything, as a code official looking at the potential hazards for a residence becoming transitional housing, the hazard is dependent on the occupancy and the use. If it's transitional housing where it's one family in one building as part of a program, it's no different than a residence. If it's 5 different occupants sharing sleeping quarters, that goes up a little bit. Now let's stuff 5 families into that building and not tell us there's any work. I would say that, I don't know if I'm going to get agreement with the gold badges in the room, but if you do anything other than a single-family dwelling for a family, and you do not allow the ability for fire prevention or fire protection staff to say, we need a bigger driveway, we need a bigger turnaround, I call that a big problem. Because right now, the way I'm understanding that language, you're hamstrung from providing additional safety measures and the ability of fire protection and first responders to get to that site in an emergency. And as you increase the amount of people in the building, you increase the potential hazard, especially if they're not all part of one family. If you've got, if it starts bordering on multifamily housing and you haven't accommodated for fire protection, fire suppression, staging of equipment, and the ability to egress that site, we've increased the hazard dramatically. And it's been one of my gripes from the beginning of the ADU thing is we've just doubled the traffic on all of our rural roads by allowing ADUs. That's a problem.
Yeah.
So if the question is it okay to increase the amount of people on these single lane roads or you know, narrow driveways? I don't think anyone's going to disagree with me saying that the answer is that's a problem.
Another complication is this. By law, a family is not defined as father, mother, brother, sister, and kids, right? A family, by law, is a group of people living together in a household. So if you look at it from that standpoint, it is very, very plausible to have a scenario in which you can have, 5, 6, 7, 8 people living, quote unquote, as a family, and they would have this, the ability to, for that kind of setting to transition into something different, which is what Mr. Infusino was actually alluding to earlier. So I think there are two things that the Planning Commission would like to know, and I think the planning staff would like to know as well. 4290 and 4291, when do those things kick in? Do they kick in automatically depending on a fire severity, or can you talk about that a little bit?
Okay, so 4290 is triggered on any new subdivision or any subdivision that is after January 1st, 1991.
It has to be a subdivision.
Or beyond that, it also applies to every building permit on every subdivision issued after 1991.
Every permit, even for as small as a single family residence.
Yes, however, well, any new dwelling, any new commercial structure. So that also means that there's also a exemption, however, for any subdivision that was constructed prior to 1991 where access and perimeters have been considered, usually by routing to the Board of Forestry. New components are not triggered. If you don't have a driveway, you have to put it in, but we don't have to consider the roadways, the dead-end roads, all that stuff. So we have to evaluate every single site, every single time to determine what level of these regulations are in effect. So I'm not gonna say it's a moving target, it's very clearly defined, but we have so many old subdivisions out there, and many of them don't have secondary access, but some form of access was considered. So now we're just looking at the lot itself and whether it's a driveway or a roadway connecting to the public access.
So in that scenario, then we can't not enforce new regulations because those structures were built prior to a particular point in time.
No, the parcel was created.
Anything in relation to the parcel, because of the new structure, we can review, but the rest of the subdivision, we can't.
I mean,
So,
most of the parcels in this county are pretty much,
Well, especially up there,
yeah.
yeah.
So
Those are
It's-
probably
but
some
it
of the
has to be
oldest
part of an
maps we
actual
have.
Subdivision, so that it was reviewed. It can't just be a parcel that exists.
So once again,
That's a
it
whole nother
depends.
Discussion.
it depends.
it depends.
So I do think that there is a question hanging out there as to whether the piece about necessary in the timber preserve zone, which is the piece that could limit what that single family residence could be used as. But I'd still like to hear from the fire guys on that the risk of even a single family residence in that area. Is there anything extra that you would want to ask for anyway?
Tom, before they speak, can you just give me the citation you were mentioning where it talks about necessary?
Sure, let me,
You said six,
bring
I
that
thought it
up.
was 65583?
I think it's in our definition.
no, that's, hold on, let me bring it up here.
Okay.
I'm not as quick as you guys are with your computers. So the okay, let's see, registers. That would be Government Code, Section 51104, Subdivision H6. And it lists the compatible uses in the timber preserve zone.
Okay, and then wasn't there a housing
Right.
section?
The,
I thought it was 655 something.
Yeah, it's government code 65583, subdivision C3.
Thank you.
And while you're on the phone here, I just sent you and the director the HCD Group Home Technical Advisory from 2022. You might want to take a look at that, because when you read it, you'll realize that conditions on these sorts of developments have to pass a incredible gauntlet of tests to satisfy state HCD. So I think Doug's suggestion that you're either going to allow it or not allow it with regard to group homes is very wise.
Well,
Thank you.
honestly, I don't think our concerns about safety should stop at the group care home. I mean,
That's
people
what
are
we're
people,
talking
right?
about.
So, yeah.
And I could see how you could have pretty large extended family.
Oh, absolutely.
living out,
You could have
managing- that's-
multi-generational,
Exactly. It's a
family living under one
business.
roof. Yeah.
So,
Yeah, just to recapture maybe for myself. So when we talk about this particular scenario, we're not talking about established subdivisions. We're talking about private forest lands used for harvesting timber. For example, I know that SPI
Preserving, but-
owns a lot of private forest lands for that purpose. And we're talking about placing something remotely in one of those areas rather than a necessary facility to harvest timber and conduct timber harvesting business. Am I correct in that?
it's so the timber preserve zone.
Yes.
It's gonna involve managing a preserve as opposed to general forestry that just is out in the forest.
Okay, so it would be either one, just a remote area.
Both, yeah.
The challenges that, for the fire district, for the fire department, EMS services or anything like that. I mean, the more remote we go, and we do have some, for example, in the fire district, like Hermit Springs Fire Station way out there off of 7N09. I mean, it's far, right? So let's just say we'll use that for an example. I would say in summertime, that's very difficult to access as far as time-wise go. It takes us probably about 45 minutes to an hour for one of our ambulances to get there if somebody's having a medical situation. On top of that, in the winter time, we have to use tracked vehicles, right? Vehicles that are designed to go over snow. And it is possible when people are healthy and ambulatory and can use snowmobiles to get to their homes. We do have areas that are remote like that don't get plowed, and it's just a very extended amount of time to get there. Now, as far as being the fire chief of an agency like that, of course, I want to limit our ability to have to do that because it takes resources away from other areas as well, right? So I wouldn't be in favor of let's add more risk remotely because it's difficult for us to get to. I'm hard enough the way it is to get an ambulance when we're there 35 miles to a hospital and then 35 miles back for the next one. Now we're talking about something like that. It could be an all-day event for something that we could have avoided in the first place. So I think we have to ease into that with a lot of caution. And of course, it's just the inherent risks of being in a timber area. And I don't know how to convey that to the people and the developers other than to put something in place that makes sure that all that's, well known prior to approving anything. Firefighters' risk, we only have so many folks. We have 8 people a day. And, to run a pretty complex medical call could take 6 to 7 of them. I mean, that's just the way it is. And when they're close together, that's one thing. And when they're far and remote and difficult to get to, then that's another thing too. So I don't know if that answers the question or not, but I tried to glean a little bit what you guys are talking about. So yeah, I'm glad you guys are talking about it, and I think it's a pretty serious topic.
Thank you.
It's a lot of discussion
Yeah.
and brain power applied to something that's a relatively infrequent occurrence. But thank you. Anybody want to add anything?
Not even that depends?
I just want to thank the gentleman for appearing and educating us today. I also want to just alert them to, we're in a situation where we have global climate change, and some timberlands are going to be more productive and less productive. And as lands become less productive, they might get sold off to more private individuals, and the likelihood that there could be more single-family residences in the TPZ is a reality, even though the risk is getting higher. So thank you for your concern and your intelligence that you shared with us today. I very much appreciate it.
Thank you. So do we want to wait to have further discussion on this until we get something back from Julie after she takes a look at those sections? And we can all take a look at them also. And
In answer to your question, though, Julie, I am quite concerned if any approval of the single-family residence necessarily includes approval of the others. I'm also wondering whether, and this is just for discussion, whether requiring the single-family residence to be subject to an AUP in the forestry preserve zone, in that would give the planning director a chance to look at the exact.
Well, yeah, I mean, I think what the suggestion is that conditions might be fraught, so it might be better. So if that's what the research bears out, if it turns out that adding conditions is legally risky because of potential HCD issues, then that
Yeah.
could, I guess, influence your decision
Yeah.
of whether to just allow.
Yeah,
it by
that
right.
definitely should be taken into consideration.
okay, yeah. Okay.
All right.
I just have one other thing that, I have a memo I'd like to get you on Friday on the subject, and if we have time, if that meets your time frame. If it's too late, I won't send it in.
What?
On this whole group
We're
home, TPC.
continuing to discuss the zoning update for longer than this week.
Okay, thank you.
I think that's what you're asking.
Yeah, I don't think we're going to get through this by tomorrow.
Yeah. Okay.
I think we'd be missing an awful lot if we did
Let's
that.
return to
Okay.
page 58.
Yeah, so we left off at the EP.
Well, and I wanted to ask, do we eventually get back to my suggestions as far as the animal provisions, but let's soldier on.
Well, I have a confession to make. I did not get to it. We have been so over the top busy in our office. This morning, I opened up my file folder to pull out a notepad and make a note to myself and went, holy cow, there's Tim's Title VI, and I didn't even bother to look at it. I apologize.
We can go back to it. But
Yeah.
Before we get on, I have this proposed additional interpretation provision. And I like the concept.
Wait, so is this a problem for him to pass this out to us? Doesn't it have to go to the public as well?
So it can be passed out at the meeting,
Okay.
as long as there's copies available to the public at the same time, yeah.
Since we
And
have,
it is, I mean,
I think there's enough
yeah.
extras here, we can put one.
I would gladly give mine up if somebody was in the audience, but
Yeah.
being none.
There's probably established wording for this sort of provision, but I thought we had to have it in there. This was triggered by the thought that maybe the animal title is going to be amended sometime in the next 5 years or something.
I definitely think a generic comment like this that makes sense. I think that wording might need a little.
Yeah, sure. I'm very receptive to it. Just for people online, this would be adding to the 17.02.020 rules of interpretation, adding under general rules, adding a subparagraph 10, saying something in effect of references to California code ordinances or to current provisions, or if those provisions are amended after the effective date of this title, to the equivalent provisions in the amended code. That's,
I'm wondering if it could be expanded. I mean, we cite to state laws that could change. Could we just say citations
Yeah.
to
Right.
laws and ordinances?
Laws, codes,
Sure.
and regulations.
yep. Anyhow, Julie, you might have some
I could,
canned language somewhere that
okay,
would apply.
it's probably in my
Current
head. I'll
editions
just have
of-
to just-
Yeah.
Blah, blah, blah. Yeah,
Okay.
I think
Julie,
probably-
Julie, maybe we can work together. This is a pretty common thing, so I wonder if we have things already to this extent in the code. So we'll make sure, or we'll work with Julie on putting some in.
Great.
Yeah, that's what I was gonna suggest. I think
Yeah, this
you
is,
guys could
this is just to trigger
slap
that.
something
Thank
in
you.
there.
Okay.
Page 58?
50.
I don't have much. This is the environmental protection overlay zone. I don't have many comments here.
We,
So Hector, do you have anything that you?
None.
we discussed, but I didn't understand where we were going. The provision, at the very, very bottom of page 58, maximum feasible mitigation measures to protect the resource and a program for monitoring and evaluating the effectiveness of the mitigation measures. The term maximum feasible mitigation measures, what if less than maximum would reduce the effects to a level of insignificance?
Right. And did this language come from the general plan?
So when I was looking at this, it came to me with a draft that contained that language. I don't know. I assumed when I was looking and helping planning tweak this, that was already in there. If it's not already in existing code, then I would agree that it would, I don't know why we would need to have the word maximum in there. That's just my take on it.
Correct me, Martha, if I'm wrong, but didn't we just carry that straight forward from existing code initially?
Yeah, and I'm looking at the existing one now, but yeah, we wouldn't, I don't believe that was something we added.
Because I looked at, before today, I thought it was chapter 1758 is where, I don't know if I have that right, but I looked at the environmental protection combining zone last night and I didn't see that language. So then it's a mystery to me where it came from as well.
Yeah, so it's not, that specific language is not in the existing 1758.
Okay.
So I think you could just take out maximum and
Right.
just have feasible mitigation.
Makes sense to me.
So I had just a couple of minor comments. One is the last sentence under purpose. The EP overlay zone is intended for areas subject to potential flooding. It seems like it needs to say, or containing sensitive archaeological areas or sensitive environmental habitats or some other language that makes that sentence read just a little better. Because it's not subject to sensitive
just say-
archaeological areas.
Could you say involving instead of subject to? Doesn't sound very
I think it's a
neat.
grammatical
Well,
issue.
whichever, it's just a grammatical thing. I don't need to tell you guys how to do it. And then the other was under development within the EP overlay zone, B3. And it says, if a new resource protection plan is required to be prepared under this section, the county department issuing the approval shall comply with CEQA land. If applicable, NEPA before approving the plan. It said, shouldn't it be the department processing or reviewing the application? Because sometimes it's not issuing an
Right.
approval.
Right. Considering.
Yeah. Okay. Whatever wording you guys are good with. And anything?
Public comment?
Yes.
On, yeah, under 17.10.010 purpose, the last sentence, the EP overlay zone is intended for areas subject to potential flooding, sensitive archaeological areas, or sensitive environmental habitats. I'm wondering if we can include something about valuable ecosystem services like groundwater recharge or carbon sequestration. Because those aren't really habitats, but they are physical characteristics that that would give you pause before you disturb the area.
So that would just, expand it beyond what we're carrying over into other
Okay.
areas. So it's up to you. It's a
Okay.
policy call. It's not that you can't do it, but it would be an expansion of what we have in there.
But I think it's consistent with what our intention would be. So what would be the language you would suggest, Tom?
Is intended for areas subject to potential flooding, sensitive archaeological areas, areas with valuable ecosystem services.
I think that's so vague that.
Too broad?
I mean, I hear,
broad.
so this section, as I understood it, is for areas that have already been identified in the
Yes.
past.
Right.
And so this was cases where we said, we're gonna put a placeholder in here. There's no immediate development that is being proposed. But when development is proposed, we're gonna go back to these placeholders and do a plan. So I just,
Or there may already be conditions. There
Yeah.
are maybe already
Right.
mapped areas, or
So-
it may require further investigation or subsurface investigation.
Right,
Is that
right. There's different,
Do we
I
even,
wouldn't recommend, we're gonna have to do CEQA on all discretionary approvals. This
Right.
is a situation where we might have already done CEQA and it's sort of implementing it later.
Well-
So,
do we need to have that last sentence? Can't we just say that, identify what, from the first sentence, what protective measures may be necessary before new development can be approved on parcels or portions of parcels previously identified by the county as environmentally sensitive or flood prone?
Yeah.
yeah,
Just take
that's
that,
true.
Yeah, I think,
that's a broad brush.
so I'm sorry, what are we
Just
doing?
take.
Just strike the last sentence.
that's problematic last sentence.
Take out
Yeah.
the second sentence.
Okay.
Leave the
Because we-
I think it was
We've
because.
pretty much already said it.
Yeah, we didn't mention, I think the purpose was because we didn't specifically call out what the thing was, the flooding or archaeological areas, but if it's already been identified, it'll show up, I suppose.
And Tom's comment would be covered by environmentally sensitive.
Right,
Sure.
right,
Okay.
okay, good.
While we're on this subject,
Suggestion.
I have a question. I'm not 100%, still 100% clear on how this overlay gets developed. For example, let me throw some examples out. CCWD has identified groundwater recharge areas in the county. Is that a previous study is that part of this overlay zone now? in the 1996 general plan, we had identified the critical deer winter range in District 2. Is that part of the overlay? Is there a map we can look at? And how is it constructed, this overlay?
No.
I'm just not clear.
Yeah, so the overlay applies to parcels that have previously been identified as having sensitive habitat, something that needs protecting, through the, through a previous studied discretionary application. So, for example, we're processing a subdivision map, and through the process of the environmental analysis, a biologist determines that there is California tiger salamander habitat, and that habitat needs to be protected. Protection of those resources is necessary to mitigate the impact. You will find it in two different ways. You'll find it, generally speaking, identified through the biological resource a study, which will then end up as a mitigation in your CEQA document. In order for us to identify that during the ministerial building permit and grading permit review process, we need to have a kind of a trigger. And so the EP overlay zone is the identification of previously identified resources that need to be protected. So upon review of a building permit, if we notice that there is a parcel that has an EP overlay zone applied to the base zone, that gives us that's the first trigger that we need to go do some further investigation. So that's when we start looking into recorded maps and what project was that associated with? What does that mitigation say? What did the CEQA document, what is it telling us to do? So that's really an indicator to us that there is something that's previously been identified and identified as a significant resource that should not be disturbed.
But we would not slap that EP overlay designation on
No.
parcels that CCWD identified as potential groundwater recharge areas, because nobody has done a study for that parcel with respect to
Right,
that.
right.
That's just that they see
Right.
those as potentially valuable pieces, but
And
we don't have the ability to go put that designation on that parcel as
Right.
a result of that.
And there's a process already in place for us to kind of identify impacts in relation to those areas. So if we are if we are reviewing an application, a discretionary application in an area such as that, we would automatically refer that application to CCWD and the appropriate agencies for review and comment relative to what's being proposed and how that's going to have an impact on those resources.
And the result of that could be.
It could.
the overlay.
It could in fact end up being the result, an overlay of some sort.
But drawing upon something Tom mentioned a while back, I think we do have to have a section in here as to how to, we have the purpose and the applicability, development required findings. We don't have a section saying the EP zone shall be established by the Board of Supervisors on the zoning map and designated with the letters EP. Just the basic, how does this happen? How does it get?
It's on
those
a
in?
case-by-case
No, but
basis, project-related.
is
It's,
that the EP zone itself?
Well, establishing an overlay zone, just like establishing a new district or making a change, is an amendment to the zoning ordinance,
Right.
the zoning code, and that's covered in administration.
right, so
Administration.
along with that mitigation would come a zoning amendment and an ordinance to reflect the zone change and the reason for the zone change.
Zone change being adding.
Yes,
EP.
correct.
Now, what about designation of EP? I don't see that in here.
Don't we already have?
That's what it is. That the EP overlay zone would be designated through the ordinance as a result of the finding of significant resources that need protection. Are you thinking that there is some sort of like, envision the general plan map that has some sort of previously identified area that
That's
should
what I-
apply, like a habitat conservation plan or
No, what I-
something?
I had
I
a project.
understand that the EP overlay zone, it's
Mm-hmm.
overlaid over the zoning map.
No, it's overlaid
No.
over an individual parcel.
Parcel,
Okay,
yeah.
okay.
So it could be on a map if it's big enough.
I mean,
you
some
can
of,
see-
some of our
Yes.
overlay zone provisions talk about, the, putting it on the zoning map, I
Well,
thought.
they are on, it will be on the zoning.
Right,
Because it will be part of its
Yeah, right.
zoning.
It's in the zoning layer. So the zoning layer in GIS reflects all the zoning ordinances as they change and are modified, right? So if you were to open up, if we were to do a query through, GIS was to do a query for us to identify all the parcels that have the EP overlay zone, they could easily do that and provide us with a list of those parcels and create a map. So, I mean, I guess in a sense, it's already mapped, but not mapped in the way that you would find, say, for instance, the general plan.
Okay.
If you
So-
look up any individual parcel and it has an EP overlay on it already, it will say something like R3 EP.
Same with airport overflight. If you
Yeah.
Right.
have a landing strip, in addition to your base zone showing up, you'll see the overlay.
Yeah.
zone.
Okay, and
Just like we do now.
if, at some point, I'd appreciate the cite to the administrative sections that do what I understand they do.
How
Martha
would you
just
choose
mentioned-
which places to cite it? It seems like it's it applies to everything.
I thought Martha said, oh, well, that's taken care of in the administration.
Yes,
Administrative.
but why would you cite it in this specific?
Well, no, if
section
it's
versus-
taken care of elsewhere, that's fine.
It's a zone. It would be under the rules for,
Well, no, he's saying he wanted this to cite.
Well, I
You can
thought-
find more information in the administrative section, but you would
No,
have
no,
to
no, no, no,
cite
no.
that
I'm
everywhere.
just asking
Oh,
where it is so I can understand the process.
Okay.
That's,
So just the administrative procedures start on page 168.
yeah,
And then amendments are,
it would be the zoning amendments.
yep, on page 215.
okay, so 215. And so that would be, the zoning amendments would be an amendment to applying to each specified parcel that's going to be EP?
Yes.
Okay, I mean,
It's that simple.
to everybody else?
It's not complicated.
Okay, that's great, great, okay.
I have one last question. Under 17.10.020 applicability, the EP overlay zone may only be applied to areas previously identified as environmentally sensitive through a site-specific discretionary approval process. Gina just explained that very well. I get that 100%. Then it says, or legislative action. And that's what had me confused, because I was thinking under or legislative action, we identified a lot of sensitive areas in the general plan EIR and in the general plan update process, which is a legislative action. But that's not how, none of those are getting put into the EP layer, right?
It says a site-specific discretionary approval process or legislative action.
Oh, okay, so site-specific modifies both of those. Okay.
We could put site-specific in front of legislative
Yes, I think-
too.
Yeah,
think we would
that
need
would be
that.
fine. Helpful.
I guess I just want to back up a little bit. So this isn't, this does not say the EP overlay zone is applied. It says it may be applied. So if the board did decide to map some maybe there's some sensitive area and the board said, hey, you know what? We want to let people know that this is there on their property.
Right.
We are going to go through this public process of the planning commission and the board and put this on the map
Yeah.
so people know.
That's a good point, Martha, because, I mean, the topic of the railroad flat, wintering deer herd, you know, the deer herd, there's different areas, there's wintering areas, there's, you know, migrating, whatever. That kind of didn't get, we used to have a actual map in the previous general plan and in this general plan that's non-existent, but that's a good point, is that, you know, if the board found it significant enough, they could in fact, you know, use this overlay zone to protect an area such as that, that maybe doesn't necessarily, you know, isn't project specific.
I love that idea.
Yeah.
Site-specific.
Site specific, well, it's an area
It
specific.
might affect many.
But I'm
sites.
saying, I mean, we could use this to overlap and not just think of it in terms of,
Yes.
you know, this is a specific site project thing. It
But
could
it
go,
still
it could go
would-
beyond that
the
if
overlay
if
itself-
somebody so saw that
But
as
the overlay
necessary.
itself would still have to be site-specific.
Right.
So I
Right,
think
so you can
wording is-
still add site specific, but I just want to like make sure you're all aware of that. This
Yeah.
is not an absolute, it's, you would still have to go through the process, whatever you want to designate.
Right.
each-
But
Well,
even if we have the legislative action language in there, it would still need to be, having been previously identified in
Right.
environmental documents prepared by the county to comply with secret.
Right.
So, okay.
right.
I think
Right.
that's all just fine.
So let's leave it as it is then. Thank you.
Good.
Okay.
Thank you, Martha. That was great.
I'm super excited to move on to page 61. Where I don't have a single mark at this moment.
Neither do I.
I mean, you're good, perfect. Then we look at 62,
Whoa.
private airport vicinity.
I was struggling through this again last night.
Me
And
too.
it's.
This is really
it's-
old language, so.
You have such great illustrations for setbacks and this sort of thing. Can there be illustrations of the airport conical zone and the, you know, all these things? It's, you know, if you, I could not picture what some of these are asking me to picture.
I struggled with its potential impact on neighboring parcels, and I don't believe that we should be. Do we have any private airports where
Yeah.
that applies to?
Yes.
And does it impact the ability of the neighboring parcels in any
Well,
case?
we applied the HL overlay to the base zone for these two particular airports and the surrounding areas,
In
so.
the surrounding areas.
Yeah.
Because it seems to me for any future, I mean, this exists, it's fine. That seems to accommodate somebody's desire for a private airport, to
You're gonna-
allow that to impact the development potential of a neighbor seems kind of beyond what I would think is reasonable.
So, and again, with this one, it would have to be an actual action that the board does, just like they did with the previous ones. When they looked at those private airports, they said, and we want to do this overlay over it.
Right.
So it doesn't automatic, if you got a new private airport, it would not automatically apply. It would only apply if the board proactively said, we also want to apply this HL.
So thank you, Martha, because I did get that from reading what you guys have here. But then I was confused. Well, could you have a private airport where you didn't have these precautionary measures?
Anyway,
Not a-
I
not
struggle.
I suppose the scenario could be that, you own and control I mean, maybe it's a 500 acre parcel and you've got your private airport
But you.
air landing strip right in the middle of this, then, it wouldn't necessarily affect surrounding properties, it would just affect your property.
Right. Okay. So is that private airport then identified in any way? Do you have
Through a use permit,
approval and when does it become a private airport and not somebody's little landing strip for his
well, even
duster?
private landing strips are noted in code as a use.
Okay.
So they're falling into certain zones of, I can't remember
they
off the top of my
have
head, but
implemented, yeah.
whatever, that you got, certain criteria in certain zones. And they all require a conditional use permit unless I'm,
Yeah, I'm
Yeah.
sure.
And I expect what happened is what, in the past, when people were doing this, they like routed it to the FAA or something.
Right,
And
right,
things are
right.
Like, oh, well, if you're gonna allow that, this is what you need to do to make it safe.
Okay.
I'm pretty sure it was based on how airplanes work and what's safe for airplanes.
it had, yeah.
So, I think we did it, right? This was added because we found parcels that had.
Right, so,
Zoning, airport zoning.
it was through the exercise of identifying the properties within the airport land use,
Compatibility.
area, compatibility plans, area of influence, that I came across these other two use permits elsewhere. Because our initial thought was that, we had this like double overlay, in this one area of land, and like I said, it wasn't until I got into the process where I found that there was, oh, well, this actually doesn't just apply to the properties surrounding the airport in the area of influence. It actually applies to other parcels elsewhere in the county. So that kind of had to change our thinking about what we were doing. So we just determined just to bring back the existing HL back into code instead of eliminating it completely. And then knowing that it just applies to parcels outside of
The airport.
the airport area of influence.
Okay.
By the way, the applicability provision was the sort of thing I was looking for under the EP. That's why talking about, it appears on the zoning map as approved by the Board of Supervisors. It's a 17.12.020. That's what raised my question as to, well, don't we need this sort of provision in the other overlay zones?
You don't need that provision. We can add that.
We can add it.
It's fine.
Like
It's not necessary, but it's.
a parallel sentence in each.
That's,
overlay zone.
I would appreciate that. I think that makes it clear. And we could have a cite to the zoning change provision in administration.
You definitely could.
So I'm all in favor of anybody that coming into one area of this zoning code because they're interested in a private airport nearby, that they get guidance as to just
How
what.
it came about.
Well, how it comes about and how it applies. And I mean, heck, all of a sudden I have an HL overlay, an HL on my property. What is that? So I would appreciate if we have some provision like that in each one.
But they wouldn't all of a sudden have an HL.
No.
Property that, change someone else's
There,
property.
there would
I
be,
understand.
there would be ample notice, yeah, there would be ample advance notice if it was necessary to make the attempt to
Right.
lay this overlay zone onto somebody else's
The
property.
neighbors would have to.
Oh, absolutely. We couldn't just process that. They would have
Yeah,
to
yeah,
agree
yeah.
to that.
No,
Okay.
that was a mistake. Okay, so did the other members of the commission read this and say, oh, I picture the airport conical zones very easily, and that sort of thing? If anybody, it would be you.
So those are So those are very technical. You would have to have an airport consultant develop those specifically.
Because, I mean, certain things, like under airport approach surface, why the surface extending outward and upward from the end of the primary surface and upward? You're gonna have surface going up from the end? There's just a lot of questions. In the last sentence, in plane, the perimeter of the approach surface coincides with the perimeter of the approach. Does in plane add anything to the?
I mean, here's the concern. The concern
Yes.
is that the language used by the airport consultant or AVA might have been imperfect to begin with, but if we monkey with it, we're not experts enough to.
We might be
monkey with it.
messing it up.
Yeah, that's was exactly my feeling. I read through it and said, oh, I'd have to plot all of this multiple ways and look at it. And do I need to do this? Because no, because if I'm trying to develop this, I'm gonna be using some kind of consultant to help me. I get the gist of it here.
Right.
I just don't think we have the expertise to
Yeah.
monkey with it.
No.
Well, we don't have the expertise to understand what it says.
That's true.
And you know, if we have confidence that somebody of competence did this to start with, then I guess we just let it go by the way it is.
That's how I felt.
Okay?
Exactly. I have one question.
Yes.
On 17.12.080 non-conforming uses, B talks about having
Yes.
to put the owner of an existing non-conforming structure or tree is required to permit the installation, operation, and maintenance thereon of such markers and lights as shall be deemed necessary. The last sentence says, such markers and lights shall be installed, operated, and maintained at the expense of the county. Not the applicant for the, not the, wouldn't you think the applicant for the airport, private airport would pay for that? I'm just asking.
Absolutely.
Yeah.
Good catch.
Yeah.
Thank you.
Maybe not use the word applicant, but the,
An operator, whatever.
Or we just don't do any,
Owner.
or we just get rid of it.
Get rid of that sentence.
And it would be the typical,
Right, which means it defaults to
Yeah.
the, yeah, that's probably a good,
okay? Then the paragraph above that, paragraph A, the last sentence, nothing contained in this chapter shall require any change in the construction or alteration of any, do we want to say permitted structure? That was begun prior to the effective date of this chapter.
probably.
another good catch.
Okay. Hey, I got one.
I think this, because this language was moved over from where it was at the county airport is how we have some artifacts.
That's
Yeah, it
probably-
applied
Yes.
to that area in addition to
Right.
other areas, yeah.
And again, in the non-conforming uses, the first sentence of subparagraph A, trees keep growing. So are we saying that a non-conforming use as of the date of chapter is fine, even if it grows 35 more feet? I'm talking about removal, lowering, or any other change or alteration in any structure or tree.
It talks about 35 feet up above though.
You might also not want board of supervisors if it's for like a use permit that doesn't have to go to them. Because again, if that was just for, if only a zoning ordinance would have to automatically go to the board.
Well, I don't understand how that applies to my concern that.
It does,
Trees
it's
keep-
another one.
It's just a second concern.
Oh, okay. I mean, it seems to me that if a tree needs to be topped in order to, I mean, a tree can become a hazard that isn't a hazard at the time of the enactment of this. If it-
Well, to take care of Julie's, we could just take out by the Board of Supervisors, because it could be by any expert.
Where's the point? Oh,
It's
down.
in B.
In B, okay.
Okay, now to the tree. Yeah, the whole non-conforming thing, and they might be a problem, but we're not gonna require to remove them,
Yeah,
was counterintuitive to me. But that private pilot should just be really careful.
You're to the right.
Yeah.
What Tim brings up is actually germane. We have this problem in the Georgetown Airport that, in El Dorado County, where exactly what he said happened. The area had been clear cut when they put the field in, but the trees grew back. And the FAA got involved and said, you can't operate your airport unless you cut down the trees. So they tried to trim down as many as they could and to get them just lower, but others they had to just take out.
Could just get rid of the word or tree.
But even if you already had a structure that was taller than would be allowed, I just don't understand how you just say, oh, it's okay, it's already there. But the tree is problematic because it continues to grow.
yeah.
Yeah, I would say.
I think the idea behind the non-conforming uses here is that you want the guy who's proposing the new airport to design his airport to avoid parts on his parcel where there are all of these interfering non-conforming uses. You say, look, we're not going to make that guy bulldoze his barn for your airport, but you've got 1,000 acres here, put it somewhere else.
I would say take the tree out. It's a different situation.
Yeah.
In that case, if you have a tree that's over 35 feet, what are your obligations? That's the owner of the tree. If we don't have the non-conforming provision in there, you're all of a sudden, after all the considerations by all parties are taken into account, you have this, you have the HL put on your land, and you don't have a non-conforming provision, you have a real question as to whether your 60-foot tree needs to be trimmed.
I'm wondering, there's a part of me which wonders if non-conforming uses belongs in this particular section for private airports. I can understand it more for the county airport, because we were basically trying to say it's our airport and we're gonna limit what we can do to private landowners. No, we have a non-conforming use section elsewhere. I don't know. That's just, do you think it's necessary?
If we just had the non-conforming use section from elsewhere apply, these trees would be authorized and they could grow as tall as they wanted, right?
But I'm wondering, do you think a special non-conforming use section is required for the private airport? For the private airport overlay zone?
I think it is, because this is exactly what people argue about in these hearings. We had one just recently in Amador County, and this was the topic. I don't, I might want to build something on my property, and I don't want to be messed up by my neighbor's airport. And the airport guy said, well, and he argued his bit, my airport's a public benefit, blah, blah, blah. So I like the fact that it highlights an issue that's relevant right up front without, having to search for
It's
it.
not clear that this applies to neighbors, like I'm looking at.
That is what.
That's where when I read it, it sounds like it's
It applies to
applying to the
anybody with,
applicant.
no, it applies to anybody in the HL overlay,
Yeah.
which is
Right.
the neighbors.
That's what I do.
But when you read the second part, what it's saying is, so if you have these non-conforming things, you can keep them, but you have to allow the operator of the airport to put in these special warning lights and markers. That's what it's trying to say here. So yeah, your tree could be 60 feet tall, and now they're gonna go in there, but what if warning markers are not enough to keep it safe? Like, what if that tree actually, not just a tree, a line of trees, needs actually to be trimmed down to,
Well, maybe keep it and just add or pruning or something, or put in a provision that allows
yeah,
for pruning.
or mitigate it in some way, right? By reducing the height, or I don't know, whatever.
I mean, the title says height limitations, exceptions. So is the idea, and maybe Martha can chime into this, is the idea to exclude these structures and trees over 35 feet from the regulation?
Yes, but we're talking about the section down below, the non-conforming uses section,
Oh, so you already finished
which
conversation
are kind of
about the
interrelated.
height limitations and stuff.
Okay, so can we somehow put in language that the non-conforming use applies to the height of the tree at the time of the enactment? But then who pays for trimming it for the future growth? Apologize for picking up the can of worms, but it's one that would arise eventually.
Well, I think that's why the sentence we took out is in there, such markers and lights. We could put that back in and say any modifications such as tree trimming, markers, lights shall be installed by the operator of the airport or the landowner.
Could we just put back or tree, I thought we
Yes.
talked about, and then just say, it's notwithstanding the provision of subsection A of this section, the owner of any existing non-conforming structure or tree is required to permit the installation, operation, maintenance of markers and lights as shall be deemed necessary, comma, or the pruning or removal of a tree to indicate to the operator, that doesn't work with the rest of the sentence. We could add a sentence afterwards that just says, if, shall also allow pruning of a tree.
Yeah,
And just
I
leave
just
it.
think
But-
we have to say that the person who's benefiting by the airport has to be responsible for doing that work.
But it's not, it would be any growth after the
Right.
enactment,
Yeah,
not, I mean, I think otherwise the non-conforming use doesn't have
Well, I
any.
think required to permit the installation already suggests that somebody besides the neighbor would be responsible for taking care of the marking of the
Right.
conforming use.
might want to be explicit about it,
Yeah.
though.
But instead of by the Board of Supervisors, to by the owner of the airport. No, I'm sorry, I'm
Well,
sorry.
Yeah.
Retract that.
To permit the owner to install, we could do required to permit the owner to install, operate, and maintain markers and lights.
On any property with the HL designation, not just their own property. That this
Well,
is
no,
the
but
messy
We're
part.
talking about the owner of any existing non-conforming structure or tree.
No, the owner,
shouldn't
that owner
be.
has to allow it, but the owner of the airport has
Right.
to actually do it. Or should have to actually do it. I
Mm-hmm.
don't think it makes sense for the neighbor to have to
No,
pay to.
So the owner of any
This
existing.
seems super problematic. What happens when
Where's-
somebody?
Where's Martha saying, got it?
Yeah,
yeah, I haven't heard that yet.
that's what I was hoping to hear.
So I guess I was just waiting to hear some consensus, but if the consensus is to add something into B that clarifies that it's the owner of the airport that is responsible for doing that, then I got it.
Yeah, but we're only talking about, if we're talking about pruning of trees, it's only back to the way it was as of the date of the enactment,
Sure, yeah.
okay?
And we could just say to the extent necessary to make them conforming. I mean, it could be along those lines.
I think we should leave it to the two
Yeah.
of you
Well,
to clean that up.
But then, I mean, then you're not giving the neighbor the benefit of the non.
No, I hear what you're saying. I actually don't think the drafting, when we sit down with it, will be super hard as long as we have
That's good.
consensus on what
That's
we're
marvelous.
doing.
I think you understand where we're headed.
Oh, yeah.
All righty. I'm just gonna write Juliet, Martha, Jean.
Yeah.
All right. Page 63.
Three.
well, no, that was 64.
I think we are
We're
60.
just dealing.
So we're
with
beyond
64.
that.
Oh, 65. I'm sorry, I
65.
misread it. 65.
Okay,
Mineral
well, this is where
Mineral extraction.
I was really getting confused because I didn't see where we were providing for an overlay, but if we have that provision in here that Martha was talking about is similar to the provision for the HL overlay,
So this,
refers to the zoning.
yeah,
map.
so this section is entirely brought forward from existing code.
I was afraid of that.
And it's also incorporating SMARA state law, which probably also is imperfectly written, just beware.
Okay, so,
And Gina, just for a little context, didn't the staff member who is tasked with implementing this in SMARA say, leave it as is, we know we need to update it, but
Yes,
Right.
yeah.
you could have saved me an hour and a half.
sorry.
Because it has all
So-
sorts of problems.
Yeah, so we have, we have consultants that we work with. We have, SMARA experts at the state. I think this is something that we need to sit down with those professionals and counsel.
And a standalone, it's too big.
Right, it's
But
too
it's a-
big
it's
to
a
try.
zoning ordinance, it's not a.
And I think we don't have the expertise to really,
So this
do
would
it
be something
justice.
that would eventually come back to us
Yeah.
yeah,
Right,
as a zoning ordinance?
yes,
right. As a mining ordinance, and then we would have just an
Right.
ML overlay that refers you to that newer ordinance.
yeah, yeah.
Oh, okay.
So-
Well,
Thank you.
It's broken, but it's not so broken that we can't use
It's
it, because
been
we need something in place. So, we
okay.
know it needs work. We'll, modify that at a later date.
If we have anything else coming up that's in that category, it'd be nice to know. So when we're reviewing it, I was trying to solve all the ills of the mining ordinance. And
My apologies.
it's, anyhow, if you see something else coming up along those lines, I'd like to know about.
Okay, so now we've jumped ahead to 79.
Yeah, didn't we?
And this is our new PD
This is our-
overlay that is traditional PD.
Right, which is the traditional planned development, planned unit development. We have removed the design review aspects of the current code, rolled those into DR entirely. So the new and improved PD is just the traditional planned unit development.
Okay. I have a suggestion on in the purpose, that on the second line, where the word plan appears, I think we ought to say plan development plan. So one or more properties to be developed under a planned development plan that provides for.
Okay, I'm sorry, say that one more time?
Okay. The purpose of this chapter is to establish a planned development PD overlay zone that provides one or more properties to be developed under a planned development plan. I understand it, that's
I would
necessary.
suggest more like under a coordinated plan,
okay.
because we know it's the plan development plan.
I
That's what
didn't.
we're talking about.
You know,
I think we're trying to define what a planned development
Yeah,
plan
exactly.
is. and so
no,
it
no,
becomes
we're
redundant.
defining what a planned development
Purpose.
overlay plan is.
Well, no, an overlay
but-
plan is not a plan. An
Overlay
overlay is
zone,
just a
excuse me.
designation.
I know, but the overlay zone requires a planned development plan.
Well, I think we're just,
I don't think we have to call the plan the plan development plan.
yeah, I don't.
Okay.
I think it's actually fine how it is, because if we say coordinated, then we just go on to say, it's better coordinated.
Okay.
It's just kind of, we're making a
many
circular
words.
definition here.
Okay.
I have a question on the 1714-040 land use regulations. No use other than an existing use is permitted in a PD overlay. So don't we mean a use that is already allowed within its zoning designation? It's not necessarily an existing use.
No, you're right.
So if we could just,
No.
Well,
So, no, so this is saying an existing use or a new use in compliance with the PD plan, because that PD plan might be in an R1 zone, but be more limiting than that R1. So you're not carrying over all of those. So it's either an existing use or one in compliance with a valid plan.
You notice you're saying valid PD plan and why we don't have PD up above under purpose, I don't know.
Now I understand why you said it.
I could see say PD plan,
Okay,
just like it is here, the short version. So
fine.
I understand what you're saying, Martha, but, okay. So you mean something that's actually already built in there? You really do mean existing?
Right.
Okay.
That the PD plan is going to take care of everything.
Anything else? Okay. I think that was it.
When we refer to, on page 80, the subdivision B residential unit density, it refers to the maximum number permitted by the general plan density for the total area. What are we talking about? What sort of designations are we talking about there? The general plan density.
Dwelling units per acre.
right.
Okay. Okay,
And that's going to vary depending on the land use designation, services, things like that.
right? Like there's areas in here where you actually have to go reference the general plan. And I was trying to figure out if we could give people a hint, but then it varies.
Yeah,
Too much.
too much.
It depends.
Yes, it depends. Thanks. But that's a good thing. People should look at the general plan now and again.
Yeah.
Anything anybody else has before we move on to the next
No,
specific plan overlay zones?
so on page 81 then?
Yes.
I'm really an advocate for putting in references to other parts of this code. So under adopted specific plans, I think we want to say, once adopted pursuant to chapter 17.40, a specific plan shall govern.
Doesn't hurt anything. Makes it a little easier.
Commissioner Laddish, are you indicating that we can only have a specific plan overlay in Copper Mill and Saddle Creek? What if we
No.
wanted to create a new
No.
specific plan area?
Well, that's what chapter
Then it would be in-
17.40
Right.
Tells
So
you how
those-
to do
tells you
it.
how to do it.
And those are the identification of the existing ones that we have right
I'm
now.
on page 81, not.
Yeah, I'm on page 82 and I'm looking at
No, no, I know,
adopted
let's-
specific plans.
Well, that, okay.
So take a
I
look
have a
at-
suggestion there too.
Right, adopted
so what-
specific plan. So if you're saying that subject to 17040, that says adopted specific plans.
That's how you adopt specific.
Yeah.
I got
think
Tim's first comment here, so now it sounds like we're talking about this.
If we're talking about that, then I think we need to say the following is a list of the county's adopted specific plans as of the enactment of this title,
right.
just to make it clear. And if you want to adopt another one, you better look at chapter 17.
Well, I think this would have to this list would get amended each time a new one is adopted, right? If we
Let
can
me take-
remember to do
You
that.
hope. I think then you could take out the language I just suggested.
Yeah. Right, we certainly will have future specific plans, I'm sure.
Well, I'm still a little confused because 15040 does not tell us how to adopt a specific plan. It only
No.
lists adopted specific plans. So what is the purpose of citing that?
Well, we're saying take it out.
Oh,
and
okay.
Correct the adopted specific plans to say,
I didn't know we were saying take it out.
well,
Yeah.
I don't think you want to say per.
We need
04,
something
although
that
it
tells us how
applies
to adopt a
both-
specific
both
plan, and
existing
and it's
future.
not here. So that's all.
Well, but I mean, looking at chapter 17.40, 0.040, initiation, a specific plan may be initiated by.
So
any
that's
board.
what I thought you were talking about, but,
That is what.
but this is, Gabriel is looking at 17.15.040. He's just looking,
But
a different section than you're looking at.
I'm lost.
That's the section that we're in, where we are on.
Well,
Yes, but
okay.
he's talking about the whole section on specific
On
plans.
specific plans.
Yeah.
And they just
Chapter-
happen to have
chapter
similar
17.
numbering.
.40,
yeah.
not
Yes.
1715.040, which
That's
is.
right.
Right, different, yes.
Yeah.
So,
Numbers.
okay, yeah,
Okay,
that
so-
makes sense, yeah.
I hope my two suggestions are still in there.
Yeah,
Oh, I got it.
yeah.
Yeah.
Thank you, Martha.
It's just a coincidence that the numbers matched. All right. Anything else? Hector, anything you?
Nothing.
All right, countywide regulations. Do we want to power through till noon, or does anybody want a break?
We need just a quick break.
Sure. And does anybody have a deadline they need to be done by today?
I have a meeting at 2:30 in my office, so I have to be there for that meeting.
So let's plan on wrapping things up by 2:00, unless it's really pretty routine stuff and we feel like we could continue on without
Yeah.
Gabriel. We'll see where we're at
Okay.
that point.
So
Very good.
just a quick little,
So quick break
5-minute
till,
break.
till what,
So 10 minutes?
Minutes.
okay.
11 o'clock?
11 o'clock.
Perfect.
Okay. Do we want to say under applicability, the regulations in this chapter shall apply to all zones, structures, in addition to structures, subject to restrictions specified in this chapter? Because there are many things in this chapter that says this only applies to the so-and-so zones, or the such and such zones, or.
What was your, say that again?
Oh, so adding to that sentence, subject to restrictions specified in this chapter. Well.
Or
limit-
exceptions.
Limitations.
Or, yeah, exactly.
Yeah, I mean, I'm open to, we have to have, I think we have to have something in there.
So it's too open then?
Yeah, I mean, it doesn't, I could probably find just by looking here quickly, there are many sections that say, no, this only applies to the agricultural sections. So limitations instead of restrictions would be fine. Uh-huh. Then,
Yeah, I keep thinking there's better wording, but it's not coming to me.
Right here in.
yeah,
Yeah,
that'd be fine.
right. Or, except as modified,
Well, that isn't modified.
whatever. Whatever. I'll let Martha. They've done a great job so far.
So down at the bottom of the page, where did we get 576 square feet?
Yeah, I had both of those.
You guys did that.
We did that?
Yeah.
Who came up with 576 square feet?
It's 24 by 24.
Ah,
A detached accessory structure.
it just seems strange that we have the basic ones, 120, plus another one that's 3 times bigger.
I had a question about this as well.
Makes no sense.
Yeah.
I like it.
Like it?
Let me say, I like it because if I'm like a builder owner and I want to build a house on my property, I can put a 24 by 24 garage up first and store all my equipment and all my, materials and stuff in there while I'm working, rather than hauling it back and forth every time. So my question about it was, I understand it can't be plumbed or there's no plumbing or electricity.
Yeah.
So does that mean it's okay, like, to put a porta potty in there and a generator so that you can have some light and power tools? Or does that mean no plumbing, no electricity? Is it just a shed?
This is
I'm gonna get this,
the ahead of the primary.
Right,
It came out of that.
right.
Yes.
I didn't quite catch the answer.
She said it's ahead of the primary use, establishment of the primary use of the property.
Yes.
But without, or provided there is no plumbing or electricity, it's hard to tell whether that's supposed to be applied to both of these accessory structures. I mean, why aren't we phrasing this in terms of the maximum of 2 detached accessory structures can be?
We had this actually come up, and so people are entitled to a shed normally, so that's the 120.
Okay.
Which, with no plumbing or electricity.
Right, which
And so
technically
it's because
doesn't
you
even
don't
need a building permit.
You could just go out there and put it up, right?
Okay.
So that's where that one came from. It's all coming back to me.
Yeah, good for you.
And then we talked about somebody having a place that they could store materials or keep
Right.
a vehicle,
Right.
whatever they needed for their construction project.
Right.
And somehow we came up with 24 by 24
Yeah,
is a reasonable size.
That's a pretty common request.
Yes.
Okay.
So again, then what's to stop someone putting in a porta potty and a generator? Do we care?
Well, Mr. Infestino's question is, well, if we're restricting the accessory structure, if we're limiting it to not being allowed to have plumbing or electricity, then his question is, can I put a porta potty for restroom facility? And can I use a generator to power up lights in a structure?
So then tools,
And
and
during construction anyway.
Right.
Yeah.
So, and I don't think we would need to address that in here. I mean, those are things
Yeah.
that are
Well-
given during construction.
Are you trying to make an argument, Tom, that it seems silly not to allow plumbing and
No,
electricity?
I'm just saying,
Okay,
can it still be a functional place for someone trying to build a house
Yeah, well,
on the
plumbing-
property?
Are you
So-
talking
so-
about somebody staying in their shed?
No, no,
Oh,
somebody like working there, they need to have power for their tools, they need to
Right.
have,
Yeah,
so I
No.
think that's a pretty common thing for a construction site is to have a
Yeah.
portable toilet in addition to having a generator so they
Yeah,
can
that's
use.
what I
But at
thought.
that point, at the
Usually
time that you're getting a
required.
building permit for a single-family residence, you've already got power to the
So what
property.
about changing that last sentence to say, provided neither is plumbed or electrified?
that's it.
Yeah.
Okay, that's
Yeah.
wonderful.
That's fine.
Underwired or
That
something like that.
Yeah.
Yeah,
Yep. I mean, plumbing to me involves pipes.
okay. I was just trying to
Yeah, I
clarify.
wouldn't,
No, I think you got it.
I think the way it's written is fine because I wouldn't
Yeah.
call a generator or a porta potty
Right.
plumbing or electricity.
Right.
But I like Julie's language.
Be glad you let me get that coffee, or that's what, sorry.
Hey, you are fast, by the way.
It was a little fast.
Jeez. Uh-oh. Moving on.
Okay, page 84?
I had only, 1716-060A, cultural resource study required. It just seemed like it should say on line 2, evaluating the historical and architectural significance of the structure instead of architecture significance. Sorry, just another little grammatical thing. Page
84.
84.
16.060. The previous section, slopes 50% or more. Now, how does the planning director impose requirements except in a UP or CUP? That is, a proposed residential development is located on slopes of 50% or more may be subject to one or more of the following requirements per the planning director.
It's a subdivision or a parcel map, not an individual project.
Oh, so residential development, you're taking that as the large scale.
Yes.
So we're talking about not a ministerial building permit application, but a subdivision map.
Or
Or
a
residential.
parcel map.
Or an
Or a
individual
parcel map.
parcel where something
Yeah.
is a conditional use or.
Right, right.
Well,
use.
Well,
but
it
that's,
couldn't be a
but that's my
conditional use.
question.
You can't
Discretionary.
increase the size of the lot on a conditional use.
But I just didn't know the mechanics of what we're
Yeah,
talking about.
that's what they're talking about
So
there.
can we make that clearer? I mean, a proposed residential development, I was thinking individual lot. I understand.
The director could pick among these, so to the extent increased lot size is not applicable, then that wouldn't be one of the things that the director would add. I'm just trying to, if
Right.
we narrow it, we might miss the situation where, I mean,
Yeah, it's still possible. You could have a
An use-
discretionary
a
permit
use
where,
permit,
yeah.
with
Should
some
we-
of these, it's just giving permission in advance to add these conditions,
Do
these
you-
types
Now,
of.
Do
do we
you
want to
want-
say one or more of the following requirements?
May be subject to the following requirements.
I'm just,
I would
It says
find
and
with
or.
one or more.
It says and or after E, but either way.
Yeah. Yeah, that's funny. That's only on the one.
But I mean, I think that means you can pick, but however you guys want to word it.
Oh, I think it was saying
yeah, I see.
any of those above, or they could just deny it.
Yeah, I'd like one or more,
I'm fine with that.
and then we can take out the and or.
One or more of the following.
Yeah,
Yes. That's fine.
so are we on, I mean, I guess, when it says residential development, should we say what we
Do you
mean by
want to
that?
say
But it could-
discretionary?
I think it's fine because like Julie said, this way it could apply
Right.
in a myriad of circumstances and
Do we just want to insert the word discretionary?
I mean, I think we wouldn't be using the zoning code if it wasn't discretionary.
well, not to apply different.
It gets back to my original question as to whether or not, just in what context can the planning director subject these to one or more of the following requirements? And, if we're talking about an individual lot, an individual parcel
Project.
project, thank you. Then does it need to be subject to an AUP?
I don't think that's what we're saying. They're saying if you're already subject to an AAP, which is somebody's asking for some kind of special consideration.
Martha?
then-
So this is an existing provision that you have. And it really actually isn't necessary, right? The planning director through discretionary action can do all kinds of things to ensure a stable, safe, and adequate building site, right? This could, in a way, apply to ministerial permits in that a grading plan is required or erosion control is required. So I think you are fine really just leaving it as is. I don't know if any additional language will make it more clear. I think ultimately what this was intended to do is just like, hey, slopes over 50% is something, like steep slope properties are something we want to kind of give you a heads up on that we're going to be looking at, and we might do these types of things.
Okay.
Yeah, that's how I saw it also.
So it's basically whenever a slope of 50% or more appears before the planning director, when the planning director has the jurisdiction to do anything about it, the planning director may impose
Yes,
one or
exactly.
more. Okay.
The next item, we're in the middle of doing, we have an urgency ordinance in place, which we're asking the board to extend at the next meeting, I would put a placeholder, I would just like cross this out and put a TBD.
Which,
060.
We're in
was
the,
it, okay,
yeah.
Yeah,
as long as we get architectural.
Yeah.
well, and it might just end up referring.
Yeah, I think
Okay,
that's,
well, once you took out the alterations, that became a lot less complex.
Gina, this is existing code language, isn't it?
I think this was
060?
changed.
No.
Oh, okay, yeah, I think we need to.
But the language.
No, this was, I think, our attempt to
dovetail.
dovetail that mitigation measure in the general plan.
So.
But obviously, all this was prior to the
Urgency. or-
urgency ordinance that's now in place.
Which we'll see at some point, and then.
In the form of a permanent ordinance, right?
Yeah.
Yeah, you wouldn't see,
And-
you wouldn't see the urgency.
So,
No, but we will see it, but it won't be for our comments. It'll just be here's.
We posted it on, we posted it on our website, so if you want to see the urgency ordinance.
so,
But the permanent ordinance is what, you know.
Right.
so I think the urgency ordinance eliminated alterations, right?
Alteration.
But the
Yeah.
general plan requires us to address it, so
Right.
that's.
Okay, so do we want to just leave the title the way it is?
I would maybe just call it historic structures and put a TBD.
Historic structures.
Yeah.
Yeah.
Okay.
Yeah,
Yeah.
let's put a hold on that one.
And the thing is, the urgency ordinance did not address all of the pieces of the general plan implementation measure that would need to be addressed in the actual permanent ordinance. There's more.
Right, or
There's
maybe
more things
in a typical
there.
historic building ordinance.
So,
Yeah, so. That's fine.
Page 86.
Yeah,
86.
so am I.
85.
Well, I mean, I
You
don't
don't
have
Well, I
any.
don't have
Density
anything there.
bonus, Okay,
Density bonus is the typical stuff.
straightforward, yeah.
Dense. but technical.
Yes, it's done.
Okay, on setbacks, I have a wording suggestion on, one, allowed encroachments onto required setbacks. A, eaves and overhangs. Eaves, overhangs, and similar architectural features may project up to 1/3 the required setback. Then I think we're talking about coming out from the house. But then the slip into not less than 3 feet from the property line, I think it'd be clearer if we said, but not past 3 feet from the property line. If you think that's too nitpicky.
Or maybe
Well, I mean,
not project within 3 feet of the
Yeah,
property
those
line.
two things have to
Maintain
be-
a clearance of
Yeah.
3 feet to the
Yeah,
property
because
line.
those two things have to be satisfied. 1/3 projection, however.
No, I
no more
understand,
than- yeah.
but it's kind of a
I know,
push me, pull you.
I
here.
agree with you.
But I
the
like
way
your
it's written.
language.
I'll let them handle it. That's a pretty standard.
Yeah, they can fix
You
it.
got that, Martha?
And we talked about this back in another section, in the measurement section.
Uh-huh. Okay, then down on mechanical equipment,
Yeah,
I add telecommunications equipment after air conditioning units. Or anywhere in that list.
so I,
Hold on. So, 1F, you wanted to
Yeah.
add.
Right.
What do you have?
I don't
let
think
me, just
telecommunications
because
equipment belongs in there.
We don't have a telecommunications ordinance yet. So I don't want to have something in here that may contradict with whatever it is we end up approving under the tele ordinance.
Yeah, we have it later on in this draft. We
The
have,
tele ordinance?
No, but we have a section.
We have a
Telecommunications
section
section.
Yeah.
for
that's another one
telecommunication.
for
It's pretty
discussion.
extensive.
Probably want to hold that till after tomorrow, when we've learned more than
Okay.
we ever
Oh,
wanted to
my
know.
And yeah, if you don't think it's a good idea to have telecommunications equipment, fine with me.
I don't,
I
but
mean,
I
that's up to
It's,
the-
it's
that's up
under
to the
such
community.
as, so I mean, other things can be included.
I mean, that's up to the
I think personal, if we were gonna talk about like where you could put a satellite dish, that might belong in here, but.
Yeah.
Which actually is covered later on. Under
Yeah.
telecommunications.
So, propane tanks can't be within 3 feet of a property line, so we need to, there's a whole code associated with propane tanks. And the closest that you're gonna be is 10 feet, and it could be more depending on the size of the tank. And so I think somehow we need to capture that they have to be in compliance with the LPG code. Only the little tiny
Well, there's-
tanks that you can hang on a building could be that.
Is a
close.
propane tank mechanical equipment?
Well, I would consider it.
You have a valve you can turn.
Well, it's part of your whole mechanical system, your mechanical and plumbing.
Unless you want to create a separate heading for that.
Yeah, we might want a separate heading and just referring to that code, and I can get you that name of the code, the actual official name.
Okay.
I have a question. On the setbacks, and we're talking about eaves and overhangings, projecting up to a third of the required setback and not less than 3 feet from the property line. And I'm wondering whether we want to, whether the setbacks for rural residential are going to be sufficient. I'm concerned, again, about the fire safety in some of these areas. I know that one of the concerns, it's nice if you don't have fire spread from home to home. And those 10-foot, those side setbacks are important to keep that from happening. And do we want to look back to see if, I think it was like a 10-foot side setback? Was that right on?
Yeah.
Residential? So.
Yes.
Then you'd be able to go, it's not really 10 feet then, it's more like 6 or 7 feet on either.
It's a third of the way in, so it's
Yeah.
3.33 feet, yes, and it
Right.
reduces it, and that's the typical allowance.
Okay, and we're good with it.
WUI designated area, that setback becomes a 30-foot clearance, which is tough because some of our parcels aren't large enough.
Yeah.
But, so
Okay.
it might be that we would want to defer to the wildland urban interface requirements, just like we say the setback is this, except that where applicable, the 30-foot clearance. And you wouldn't want to allow a third of the way into the 30-foot clearance. So I don't know how other places are handling that.
Maybe what we can do, so if it's required, for fire safety or the building code or electrical code or any other codes, like these do not supersede those. So maybe it's just expanding on, this up here, requirements of the building code, fire safe regulations, and all other applicable
Perfect,
codes.
because those are changing all the time, and
Right.
so Tim's additional requirement will take care of that.
Yeah, okay, under allowed encroachments, it said unless limited by another regulation or permit requirement.
Yes,
Okay.
that's a good solution, thank you.
Are we adding that language?
No, I'm just reading from A1.
She's gonna modify the
Okay.
A1 up there.
Well, I think I think she was reading from A itself. Right, Martha?
Applicable requirements of the building code. Then she,
So,
maybe.
yeah, I was talking about, I realize it kind of states that here, but I was talking about A1 and adding this
Okay,
after.
great.
Okay.
Perfect. No, I had a question on page 87, the stream and wetland setbacks. And again, it relates to the fire safety. So if maybe because we have a minimum 50-foot setback anyway, but you have 100 feet from the house that requires you to minimize the understory. So are we gonna have a conflict there between the fire clearances and not being allowed to remove vegetation? I thought maybe if vegetation shall not be cut or removed except for normal maintenance to facilitate drainage, prevent flooding, maybe we could say, or comply with fire safe regulations.
Yeah, I can see that.
We can leave that one with Martha too.
And I think that's fine because if you look at what CDF is recommending now, it's the first 50 feet have to be from the home. They want sort of bare ground. Beyond that, they sort of want, reduced stuff on the ground, but they're allowing trees and stuff. So it's not bare soil for 100 feet.
No.
Yeah.
Okay, on page 88. Agricultural buffers. New residential dwelling, building sites and structures or outdoor areas designed for residential habitable space shall maintain a buffer separation from any lot line of any lot in the resource protection and general plan land use area. And I wondered about that applying to RA where the parcel might be smaller. Because it's 400 feet.
Right.
And I looked.
So there is that, through the administrative use permit, you can
Reduce.
reduce it,
Yeah.
right? And one of the reasons would be because the site size is constrained and the buffer's infeasible.
It just seemed like requiring them to get an administrative use permit in a situation where it might be difficult to comply.
Yes.
That was my only question.
Yeah.
Is that reasonable?
Kind of like,
Well-
it's kind of like asking for a variance.
And what the AUP does then is allow the agricultural commissioner to say, okay, but
Right.
do these different things and that will help protect the agriculture on the other parcel as well. So you can't provide that size, but if you position your home, it just allows some case-by-case analysis.
Yeah. Martha, I noticed that we went from 300 to 400. What is the justification for the increase? I'm not saying it's not right or wrong. I'm just saying, why did we go from
Well,
3 to 4?
We had a range and the planning commission decided that instead of a range, let's just meet it in the middle and call it 400.
Well, because who was gonna determine which number in the
Right.
range was gonna be the one?
Mm.
Okay, well, if everyone else is comfortable with that, I don't have any big
Yeah,
objection.
it's a lot easier to require administrative use permits if they were free. And just, you know.
They can't be free.
Here,
because
here,
they
I
take
know,
staff
I know they
time.
can't be. I'll form a foundation.
Yes, there you go. Yeah, we're just trying not to unnecessarily burden the applicant, but.
Right. At the same time, I know it's important in your county to protect the agricultural operations for that long-term viability. So it is that balance, right?
Yep.
Yeah.
And when reviewing new applications for subdivisions, obviously we'll take that into consideration so we don't have any problems.
Well, I don't, really, we wouldn't be calling a 5 or 10 acre parcel RA most likely in the future.
Yeah.
It's just something that's existing,
Right,
right?
right.
Yeah. Okay.
Okay, moving on to 89.
Yeah, and the height exceptions. This sounds like a blank check here. Communication antenna, poles, silos, stair towers, mechanical equipment, and safety devices may exceed the maximum permitted height for the zoning district in which they are located, subject to limitations within the airport overlay zone. It seems to me that maybe they should be subject to AUPs. I mean, we're just saying, oh, you want a stair tower, whatever that is, you can have it at 600 feet tall. As long as you're not in an airport flight overlay zone.
Not necessarily, Commissioner.
I hope
I don't see any of those that would be standalone.
I mean,
okay,
well,
telecommunication antenna.
let's take a low-hanging fruit, for
Right.
example, a flagpole.
A what?
A flagpole. You know, so you're a patriot, you want to fly a huge American flag, and
Right.
you want to stick it on a 60-foot pole. Now,
Or 150.
or 150-foot pole, like the guy in Long Beach. So, so I mean, would you want that to be subject to an AUP? You would?
How unpatriotic.
I think maybe we could limit the increase in height for certain things. So I'm wondering though about stair towers. Like, I assume that comes from a commercial situation where you need access to a roof and you have a
Right.
stair tower
Right.
that's in the middle and it's sticking up a little bit, you don't even see it.
And mechanical equipment could be that's on a rooftop.
Exactly.
Right.
But
And
I
and
think.
Gina, just for some context, so this is your existing provision that
Exactly.
generally staff has
It is,
worked.
yeah.
There was a request by staff, I think, who implements this to add the stair towers and mechanical equipment. So
Yeah.
that's where this came in.
Right, I can see it, I just think maybe we should say that it can exceed the height by
Yeah.
to some percentage or a number, not just carte blanche like Tim was.
So these are, I have a question. Are these discretionary applications that will later go to the
No,
planning commission?
No.
Or these are just, oh, wow.
No, no.
So,
I mean-
Tom, hold on.
I
Tom.
agree.
This language currently exists in the code.
I
The only-
understand, but-
The only change is
But-
adding stair towers and mechanical equipment to that language.
Those are things.
Telecommunication antenna have their own regulations, right, for height. And
so I know that in other counties, the radio tower issue comes up a lot, and it's usually done in a discretionary format. Are the radio towers done in a discretionary format? in
no, we're
Calaveras?
talking
No?
like a ham radio
Radio.
tower, then no, those.
Yeah,
Yeah,
16,
They're not subject to discretionary application.
yeah, they're
at
allowed,
any height,
Right.
right.
Wow.
Because they serve a function that during an emergency, they do
Sure.
come in handy.
Right, but if you recall, in the general plan, there's a whole provision about when considering emergency telecommunications, we'll consider how to make them, environmentally sensitive. So it surprised me that the telecommunications heights are,
Yeah, in most jurisdictions, ham radio operators have been kind of exempt from discretionary processes, again, because of the safety, because of the value they bring in an emergency. And also, those things are retractable. You can crank them up, you can crank them down. Your other strictly standalone structures, I can understand regulating those, but ham radio operators have always had kind of a free rein. And they don't abuse them,
I don't know that they're all retractable, but.
Yeah, exactly. They're all retractable.
With the question about whether these are permitted, my read of the zoning code, and let me know if you have a different read, is that this just says to the extent a structural height, for example, that's given in a zone is exceeded, or to the extent there's a limit on like a building height.
Yeah.
Right.
This could go beyond it, but it's not automatically saying there's no AUP for telecommunication towers, or it's not separately, a telecommunication tower
Right.
could require.
Right.
AUP.
Right.
There is a
Exactly.
discretionary
Make
option.
any of
This
these
is
things.
not
that just-
talking about a telecommunication tower, it's an antenna.
Antenna.
But-
It means like
Yeah.
your TV
But
antenna.
it wouldn't
But
be
I-
mutually exclude,
Right.
having
Yeah.
something like this in here does not automatically, doesn't speak to the type of permit that might be required.
Might
It
be
just
required.
says, here's a situation where we
Right,
might
right.
exceed.
Yeah, but
Yeah.
we're talking
But
about
it-
user-friendly, and then somebody, okay, I want to put in a pole, a big pole. I want a big pole. And so I look at this and I say, okay, I'm going to go out and buy myself a 150-foot pole and put it in.
Well, I mean, hopefully there'll be other sections of the code that would address that, but I think
But we
Julie's
better
point-
say subject
Just
to.
say by
Yeah.
a maximum of 10 feet or something that would cover the vast majority of the kinds of things we're talking about that we want to just allow people to do.
Because stair towers and mechanical equipment makes a whole lot of sense.
Yeah.
So,
And if you're
10,
doing
15
an
feet.
antenna or a pole or a silo on your building, that's more than enough
I,
for
I,
most situations.
So-
I think our maximum building height in any zone is 35 feet.
Well,
No,
residential is
50 feet.
35,
Yeah.
commercial is 45. I don't recall what it is in industrial. There's no height limitation on ag structures.
And
Because
so
of
that-
silos
yeah,
and
not
stuff.
worried about that
Yeah,
stuff.
yeah.
So, but I thought for residential and commercial, the two places where you would really be
Mm-hmm.
concerned about it, 10 feet is gonna give you enough. And if somebody
10
needs
feet
to
above
exceed it
the-
by 20 feet, they probably need an AUP or a CUP.
Well, maybe that's where you can then subsequently require the administrative permit if
Right.
you're going to exceed 10 feet above the maximum
So qualify.
height within the
permitted
zone.
height for zoning for the zoning district by 10 feet, qualify that.
So by a maximum of 10 feet.
Okay.
Subject to limitations.
And then you can, instead of saying subject to some limitations within the airport overlays, then you can subject to other limitations within this title.
yes.
Yeah.
Because we'd have to get into the
Exactly.
HL overlay and everything else.
I think that's a good fix.
Uh-huh.
10 feet doesn't.
Will 10 feet do it? I mean, just thinking of mechanical equipment and stair towers on the top of a
Well,
building.
a stair tower wouldn't usually need
No.
more than
'Cause
9
it's-
feet or so.
Yeah, it's
You-
just to get to the top of the building.
Yeah, no, I
And
understand.
So,
Co-locations have to be allowed by rate, so I
Yeah.
don't know. I mean, again, to the extent a telecommunication antenna counts as co-located on a permitted tower, we can't require an
I don't
AUP.
think this is talking about that though.
Okay.
I mean, I think this is talking about personal antenna.
Yeah.
Like
It's a little
the
misleading though.
radio.
I mean, the word telecommunication
Yeah.
antenna leads you to believe that we're talking
Two-way.
about
We
a
could just say.
full-on
Just
cellular.
said antenna.
Yeah.
That seems,
Good. Like it.
yeah.
Yeah, because the telecommunications section actually discusses height, which gives you the
Yeah.
allowance to go higher than, obviously,
Right.
your,
I think we've got it.
And we had some of that in the base zoning too, exceptions. Okay.
So-
Anything-
I'm sorry. I was going to lighting and illumination.
Well, I'm wondering if we ought to maybe touch upon it and then go to lunch, but it's,
Okay.
I think
just- I
there's
have-
going to be a lot of discussion.
I have a very simple question, and that question is this that section that's going to be the dark sky?
Yes, that's,
Okay, good. That's all I wanted to know.
That's what we hope, at least.
That's
Yeah.
what I wanted, because it came up yesterday at the board hearing. I just,
And just at I don't know if anybody was listening to the board, I mean, the board was expecting a separate dark sky ordinance, and we explained that the goal, that Gina and Martha have been working on, trying to just incorporate that into the lighting and illumination standards of the main zoning code update. The board was fine with that as long as it covers, you know, what at the end of the day they're gonna want to cover. We don't have specific direction on the details of it, but just understand that.
except that they want it in track changes.
Well, they want to see it in tracking, that's right. But just understand that this is supposed to be the dark sky ordinance.
that was the compromise.
So
Yeah.
I,
We want to see it before.
just
and
as a heads up, I believe that might be difficult to achieve adequately, but we might be able to cover at least all the topics here and then still come back to the dark sky ordinance at a later date, but cover most of the things that have come up that we're constantly conditioning things.
So now, because it's a quarter till noon, is Tom saying that we should not, oh, I'm sorry.
Oh, my.
Freudian slip.
Tom has him already for
I think it.
Are you saying we should not even begin the discussion because there's going to be a lengthy?
Well,
Well-
the first thing I'm gonna say is, why in the heaven's name are we exempting street lighting? And that's gonna take a lot of time to talk
Okay.
about, so.
So
Madam Chair.
I actually think maybe we have a short discussion, what we can have between now and noon, and that we defer this to come back to it with the knowledge that we're trying to cover it, everything here.
Okay,
That it might take a longer discussion and that we could get a lot further through the rest of the code and keep this like with the animals, a bigger discussion to come back to. That way we'll feel like we have made a lot of progress today, and that makes me feel good.
I think,
And
but
that's what's most important.
I suggest we go to lunch now because the lines are gonna be longer in 15 minutes than they are now.
The line's okay.
I have one question about this. And I have a question about, there's a separate section on signs and sign illumination. So are signs not going to comply with this?
No, I
But-
have that marked also.
Yeah, no, signs are already subject to illumination levels anyway, so,
Right.
and I think those, go ahead, sir.
The distinction I would make is that in the old days and still, people illuminate signs now from below, causing the light and glare problem. So I think that you could harmonize the two so that you could illuminate signs to the level in the sign standards, but illuminate them, like from above pointing down, so that they would also reduce the light and glare. That's just a thought.
I agree.
Okay,
Okay, so is everybody ready to take a break? You want to just go, so is 45 minutes long enough if we go now? Because the lines are short.
yeah, well, hopefully.
Tim, you can drive with me.
She's
Hang on.
exactly, yeah.
We'll meet you then.
Do we want to return at
12:30?
12:45 or 1?
She was saying 12:30.
12:30.
Oh, 12.
But I'm okay with 12:45 if that's what you guys want.
Well,
12:45 is an
Only
hour.
50 minutes, it seems to be my magical
Okay,
time.
Okay.
so 12:35?
Yep, that's right.
Yeah, it's an odd.
12:35.
The special meeting of the Planning Commission is back in session. We are getting ready to start on section 17.16.100. I don't know if Martha's back or not.
Well, I think the idea
Yes,
that we can talk without getting into specifics.
right.
The idea, if this is to be the night with the dark skies ordinance, I think the idea of having some discussion right now, but then coming back to it is essential, because this is not a dark skies ordinance. But I think having a quick discussion as far as where we see particular problems, as I indicated, may I continue? I don't see any reason to exempt public and private street lighting. Other communities' dark sky ordinances have very elaborate provisions on that, and under this, why you could have, even a private street could have extremely bright lights that point in all directions, including up, and be much broader than the street. And I mean, it's just, this is not a dark skies ordinance provision.
Well, if you guys think that we can roll in, provisions that meet the intent of that general plan implementation, then this was our first stab at it. So, if you don't think we can quite get there without a separate ordinance, then certainly, I suppose at some point that we'll have to take that into consideration. But if you think that this language can be modified to meet all of your concerns, then I would suggest that we do so.
Yeah, well, I'm not saying throw the whole thing out.
Right, no.
Throw out exemption A, but, and then athletic field lights. I was not educated at all when we looked at this before, and I assumed there must be a reason to exempt public and private street lighting, but I don't see that. I don't see exempting athletic field lights used on a park. I mean, I think that's another source of egregious, can be a source of egregious light shining up in the sky. But I understand that if a public school district has made certain provisions that we cannot regulate their athletic field lights.
I think this is for temporary, maybe during a football game or
Right.
something, right?
Well,
I think
yeah.
that's the sense I got.
Or practice,
Well-
or whatever.
They're not going to leave athletic field lights on all the time.
No, but they can be, I mean, park lights can be directed.
Park lights,
Right.
Public school lights were
Yeah, they
need
have
to
to be
exempt.
exempted.
Yeah, I mean, we assume that they've taken the proper
Right.
steps.
Just in the interest of, I know you've been working on the zoning code for a long time, and the dark sky is a concern. Just in the interest of kind of moving forward, I wonder if we could just take out A and B as far as exemptions. And then I do think separately you want, even if you took this then and adopted it, you do want to look further at dark sky and kind of see if this covers everything, because there are, again, this is the zoning code, so that you can think of this as kind of like applying on private property, right? So in your dark sky ordinance, you might be looking at something broader than that in the public right of way with the streets and, you know, street code and so on.
Yeah, well, I
So
think, Martha, it might have been before you came on, but what we're talking about is having some general discussion today, but coming back to it later. And maybe, let's see, it would be appropriate if two commission members work together on something like this, wouldn't it?
So I believe that Maddie started a black sky ordinance a few years ago. A black sky, a dark sky.
We didn't actually start drafting one. We were looking into it.
She was gathering.
We were gathering information,
And
right?
I know that because we talked about this way back a long time ago. And I have a bunch of dark sky materials that I saved at that time, which I just like to go look at. And then maybe we could look and see if we could take the major things and roll
Right.
them into this.
Sure.
Even if we have to do a more comprehensive
Right,
one later.
right.
But I
But if
think-
we can address the majority of our major concerns through this ordinance, you know, I know that the dark sky ordinance is absolutely a priority of the Board of Supervisors. So that is on our list, and it's
Maria
pretty
might
high on the
come
list.
for me.
But at least if we have, you know, some stricter provisions in place now, then, you know, if there's still a desire to get even additional and have that separate ordinance, then of course we can be working on it, but at least we can feel a lot better about, you know, the direction that we're heading in.
Right.
Yeah, and along the lines of exemptions, we talked about B1A, B1A. I mean, I've seen some security lighting that is absolutely obnoxious. They are overly bright. There's so many of them. So I think we want to consider C as well. I think you can have tasteful security lighting, but when you exempt security lighting from any kind of regulations, it lends itself to just totally just lambasting the entire landscape with lighting.
So it's just a point of clarification, it's not any safety and security light, it's for public safety facilities. So that would be your police station.
Right.
Okay.
So that wouldn't include the quote unquote
Courthouse.
security lighting at the, you know, local industrial,
store.
you
Yeah,
know,
like those guys.
building.
Yeah, those
Right.
guys. Okay,
Yeah.
well,
Yeah,
to
that-
that extent, yeah.
Yes.
And when we discussed this before, I didn't know what the technical meaning of fully sufficient, let's see, fully shielded or fully cut off meant. And, you know, I'm be much in favor of restoring on page 90, the fully shielded instead of sufficiently shielded, that sort of thing. I think we need, I don't know that we need to discuss this anymore today. If the chair wants to take on kind of a,
Well, yeah. So Hector, do you have anything on this section that you want to say?
I do not, didn't we go through some of this material previously?
we did, and at that
Legally.
point, I didn't know what fully shielded just means. It sounds like no light comes out.
No.
It just means nothing below the level of the lowest part of the light.
But my question is, we had this conversation, didn't we, several meetings ago?
When we did the first, we
Go around.
briefly looked at it when we did the first go round through here.
When we were looking at the sections.
Yeah.
And now?
And now we didn't really I'm not even sure it was as fully developed as it is now. It might have been.
Yeah.
But
I
we're
think with a
talking-
closer read, they're finding that, it could be improved.
Okay,
Right.
okay, well
To
then,
make it sufficient to hold us over until we can get an
Right.
actual ordinance in place.
Right.
And it is a requirement of our general plan, and it's something that's been hanging
Right.
around for
So
more
just,
than 10 years.
yeah, just to catch you up, the dark sky ordinance has been a requirement for a very long time, even prior to the adoption of the most recent general plan in 2019. We've been talking about dark sky ordinance for a very long time.
And
So,
one thing that isn't yet covered is about existing lights. I know some dark sky
Right.
ordinances say that if there's any sort of a building permit is issued for any property, why you have to update the lights to meet the new requirements. And that's a subject we have to consider.
yeah.
so this section is requiring yet a
So-
little refinement.
So we didn't previously have a lighting section. It was some very general requirements that were rolled into like the performance standards in commercial districts. Didn't apply anywhere else. And so this section was written by Martha and myself as an attempt to try to satisfy, the idea of a dark sky ordinance. And it is the first attempt,
You see more room for improvement as well then.
huh?
You see more room for revision as well.
There might be, and that's why we need to have the discussion, because, we've got people here on the commission that have, experience. I mean, Michelle's, she's familiar with, as an architect, she's familiar with building code requirements and, and then, so we've all had these discussions for a long time. And so, like I said, this is our first attempt at it. We recognize that there's probably some room for improvement, but whether or not that's actually going to require a whole additional ordinance, or whether we feel that we can get there through this code amendment, we'll see where we can go with
We
that.
could get most of it here, that
Right.
would be great. The other thing is that the building codes have incorporated a lot of stuff into them that in the interest of reducing energy consumption that actually address a lot of these things. So some of it is kind of partially taken care of that way. And we've been conditioning every project that came in front of us with these requirements. And that's why we've been wanting to get them built into the code, so that we're not every single time telling people the same thing and having to add that language in. So, yeah,
I think-
I agree. We could all go home, Google dark sky, look at an example ordinance, come back with our thoughts of what are the most important elements to incorporate.
If Michelle, if you're willing to take a crack at a revised draft, I think your expertise would be invaluable.
Well, I'm willing to come back with suggestions.
Right. Right. And I think what you presented to us is great as a discussion starter.
And that's pretty much
That's some of the
that's pretty
discussion.
much what we anticipated.
Yeah, even if some of the discussion is, what?
Yeah.
Okay?
Okay, so moving on. Non-residential outdoor storage. I think it says none now.
Yes, right. There's an extra E. On applicability, can't we just say, do we need the words "of a building"? Because the standards of this section shall apply to storage of goods, materials, machines, equipment, and inoperable vehicles or parts outside for more than 72 hours. If we say outside of a building, why then, then you have to have a building for it to be outside of? on
It
a
says
particular
outside
parcel?
of a building for more
No,
than 70.
no, but I don't think we need of a building.
Oh, you're trying to
Just
get
need
rid of it.
outside. The parcel doesn't have a building, it's still outside.
Outdoors,
I don't think you'd be allowed to have outdoor storage without a building or primary use on it. Right?
But it currently happens a lot.
Yeah, oh, it currently happens a lot, I agree with
Yes.
you.
Oh, my goodness.
so having the building.
There may be a use that's
I
not
think-
necessarily needing a building.
No, I think Hector's comment about parts outdoors for more than 72 hours is probably,
Yeah, that's better.
That's
Yeah.
fine.
so take outside of the building out
Yeah.
and put outdoors.
Outdoors at all.
Yeah,
Thank you.
because that's what we're trying to regulate.
It is outdoor storage. Why did we take out, in B, why did we take out outside of all required setbacks?
Oh, you can store things within setbacks.
No,
Yeah, it's not a structure.
no, I know, but, okay.
I think maybe we would want to include in here that it can't be in the public right away. I mean, that's implied, but it's an issue. So maybe just say entirely on the parcel.
Under B,
Yes.
Keeping in outside of pedestrian way.
Well, I was just adding it to the maybe previous, like entirely on within the parcel outside of
Yeah.
pedestrian ways.
Fine.
Yeah.
Yeah. Now, so with the perimeter fencing involved, so maybe it's covered in here. If you have patio furniture in your front yard
No.
that you keep out there, is that,
No.
no.
That's
Doesn't apply.
No.
why isn't it?
because it's being used.
It's
not
being used, not being.
If it was stacked up,
Uh-huh.
7 feet tall.
Yeah, okay, okay.
Is it? I think that it?
Yep, that's it.
Okay.
I'm really sorry we can't get into cannabis retailers. and
Well, you
cannabis
don't want to
cultivation.
talk about rice farms, swimming pools and spas,
I
and
don't need-
visibility intersections and driveways.
If you have something,
I don't have anything. Anybody else have anything? Okay. Now, yes, and then I feel totally comfortable with flipping right on past all the cannabis stuff.
I have a question. So when is it that, I notice that we always flip by it and we've kind of gone, continuing to leapfrog over it. Where is that? What is it? And when is it?
Oh,
Okay.
the
Well-
sections that aren't written in here?
Well, particularly with cannabis.
Yeah, so-
Have a whole separate cannabis.
So
It'll-
cannabis is in 1795, and that has been, there's a division of cannabis control that has to keep responding to a combination of state law and changes in our county's program. And so that has, those changes are up to date as far as what the Board of Supervisors is wanting to see. So I don't think the board would want us to recommend amendments to that
Right.
as part of this.
So they're basically not applicable to what we're trying to achieve here.
Is that
These are
because they're the
placeholders.
ones that are taking the lead?
They could come back to us for us to look
Okay.
at them,
Right.
but they would come back separate.
Yeah,
They're taking the lead.
we're just not reviewing those for modification under this particular
But
exercise.
they will be.
This is
in
very
here as
specific.
Chapter 17.17.
And there are actually some changes being anticipated, but that would come alone as a
And
standalone.
we just did a little.
Yeah, there's other sections of the code
Adaptation.
outside of the zoning code that also apply to cannabis.
Thank you.
Sure.
So are we moving on to landscaping?
Yes, we are.
See here.
I'm wondering how much we're trying to accomplish with this section. We've needed a landscaping ordinance for a long time, or a landscaping section.
Yeah, that's a very good question because it also came up yesterday at the board supervisors meeting. We do need a landscaping ordinance, but I think in the interim, what we've been going by has been standards that were adopted by the state, and they're not very. It doesn't lend itself to developing a landscaping plan for a project. I mean, typically, so because we don't have percentages on shrubs and trees and ground cover, et cetera, et
Right.
cetera. We don't have
Like we do
irrigation
now.
standards. We don't have a lot of things that you customarily see in landscaping ordinances. So I think this one kind of goes along the same lines as the section dealing with dark sky. I think maybe the landscaping section should be something that we kind of table because part of the directions given by the Board of Supervisors through some other programs going on in the county is calling for developing a palette for that leads towards adopting a landscaping ordinance. So, I mean, to the extent that this is a placeholder and provides additional clarification, I don't see any harm in it, but by no way is this going to represent what you might want to give a prospective developer to say, hey, here's a landscaping ordinance, go and design one for your project.
Well, that kind of answers my, should we be adopting some model code? Should we be writing a landscaping code?
We
Do
have adopted the model water efficient landscape
Right.
ordinance through the green building code. So that
Well,
is. a
actually,
requirement.
they're different. The Green Building Code has different stuff in it than I looked up this model water efficient landscape ordinance, which is a little bit of a different animal,
Yeah.
Yeah, but
which I think is fine. I think maybe we
We're
should
rec-
reference both of them here.
You know, it's funny, I did have to work with the building official on this once, and when I looked at it, and this has been a few years now, it did appear that in what was adopted with the model codes, that it did, I saw a section in the green building code that did loop in.
Oh, the Green Building Code might loop this part in, but the Green Building Code, I think, has some different things also in it.
Oh, yeah, but MWELO is a sort of we can't go below the MWELO.
Wheelo.
It's a
Yeah.
MWELO, it's a minimum standard.
Well, all I'm saying is, well, perhaps we should also reference the Green Building Code requirements. That's all. Just if we're just doing a placeholder thing and trying to keep kind of a simple thing, we could reference both those, which they're required to do anyway. We're not doing anything extra. And then I think, the areas to be landscaped, I think all that is fine. We definitely would need more direction? Because this comes up every time we have to do a landscaping plan.
Well, one suggestion that has nothing to do with the green building code or anything is under the purpose paragraph, since we're talking about something to reduce this, enhance that, conserve this, it should be ensure and not ensuring
Yes.
ongoing maintenance. By God, that's something I can.
That one too.
Now, we don't define landscape projects anywhere, but we define landscaping, and it doesn't seem to, this is on page 258, and it does not seem to encompass native plants, especially native plants that are already there.
Yeah. And that's one of the things that
Discussed.
the palette that we've kind of put together is going to be it's going to recognize a native not only native plant species but also invasive species that would, if you introduce them, would actually kill native plants. So the more I think about this, the more I think we should just have this as a placeholder while we work on a regular landscaping.
Are you saying pallets?
Pallets.
Palette, like a palette of materials
Yes,
to incorporate.
yes.
Okay.
Not the crates
Right.
Yeah.
Like an artist's palette.
or that.
Yes. It's a designery planner kind of a word.
See, we got Tim on that one.
This
Yeah,
does
you did.
say
It wouldn't know.
existing natural
No,
shrubs and trees may be. They did add that, existing natural shrubs and trees may be incorporated in all the sections, so.
Yeah, it's the definition.
I think he's
of
referring to the
Yeah.
definition.
On a
yeah.
different page.
landscape. It could be broadened up.
One of the things is, are these things intended to apply to projects whether or not a building permit is required? Because the green building code only comes into play when somebody's doing landscaping while they have an active building
Oh.
permit, and most people studiously avoid that situation.
Yeah.
Unless landscaping is required as part of their zoning
Mm-hmm.
requirements, like in commercial. And maybe that's fine if we're not trying to.
Well, I mean, to the extent that I think we're trying to rectify an existing really significant lack of landscaping, we could apply it either at a discretionary stage where we're actually reviewing a subdivision application, or a ministerial in the case of a property that's been left neglect for quite a long time. So.
Well, this says where the areas are to be landscaped. It applies to some residential, not single-family residential.
Right.
Right. So I think that's reasonable. I will double check the green building code reference and send it to you.
Okay.
And otherwise, are we able to accept this as
What it is.
for what it is? Yes. Okay, great. Non-conforming uses, structures, and parcels. Seems like we,
Before we move too far, do we want to address the native plants in the definition, Tim?
sure, do we want to do it now?
We can do it now, or we can do it when we're going.
When we
through
get
it.
there,
Yeah,
will we remember?
I'm putting
You're
it.
marking it
I'm
down.
putting
Okay,
it.
all right, we'll keep moving then.
Yeah.
Okay. Seems like we beat this piece up a lot last time.
Yeah, we talked extensively about this section, and I'm assuming that the changes you would see here are derived from the discussions we had the last time.
I had one note there, and then I crossed out, but now I'm concerned about, what, on applicability, how do we cover non-conforming structures or parcels or whatever, that were non-conforming became non-conforming, prior to this current
I
chapter?
think we had that discussion.
Yeah.
Yeah, we did.
And we
We did.
solved it.
We did, but I don't remember how we took care of it.
They're just still non-conforming if they were legally established whenever they were established, even if the code changed 3 times since
Right.
then,
But that,
they're still legal non-conforming. They were legally established.
I just don't see where we provide that. I understand what you're saying, and that's my understanding. But this,
So it says it here, but I think the subtlety here is it was never conforming, those we're not talking about. It never conformed, and it's not like it predated the codes.
well, no, I'm
Yeah.
talking about that it conformed at one.
Tim, if you look
Well, it
at
says that.
1721-030 general provisions B,
Yeah.
any use or structure that was lawfully established prior to the effective date of this title or of any subsequent amendments to the text of the zoning map may only be continued and maintained provided there is no alteration, enlargement, addition, et cetera, et cetera. Does that kind of, if you want to take a read?
Oh, I see, that, by lawfully established prior to the effective date of the.
Yeah,
Okay, it
Because
just does not, that is dealing with what I was talking about.
Yeah.
But it just isn't
address it.
covered in applicability.
yeah.
That's probably why I crossed out my suggested change. Okay, if nobody,
So maybe this should say the provisions of this chapter apply to legally established
Yes.
structures, parcels, and uses that have become non-conforming by adoption of this title.
by subsequent law or this title.
Yeah, blah, blah, blah.
Yeah, that would do it.
Okay, we say legally, so that means if they're
Whatever.
illegal, then they're just illegal. They can't be deemed to be non-conforming because they were never legally approved.
Right.
Yeah. Julie,
I
legally
don't-
speaking?
I don't have any problem with saying, adding in applicability legally established structures, and
Okay.
that makes sense.
But then we have to, that have become non-conforming by subsequent law, including the adoption of this title.
I mean, I think that's implied in there, but
Yeah.
if you went
And I think it's,
to its text,
yeah.
which would include, I think, I don't know that we have to expressly say including this title, but
Okay, subsequent law.
Now, I hate to do this, but we've come across quite a few instances where we don't even know the history of the establishment of a structure. No, it was done sometime, we don't know how, we don't know when, we don't have any records of it. So we can't really say it was legally established. It could have been illegal, but we have no way of knowing that.
we
How?
can make the applicant have the burden of proof.
Right. And we say it's legally established if it predated our zoning.
As the
or
owner of two
building code.
1875 buildings, I don't know that I like that idea.
That could be.
Well,
that
I
could
think
prove to
we
be
just have to
possible.
assume it was, at some point.
We're gonna have to
legally-
assume
The
that.
zoning code didn't come into existence, I don't think, until the 1960s.
60s.
Okay.
Right.
So anything before the first zoning code is
Is,
going to be legal non.
Okay,
Right.
I would be happy if we have the provisions of this chapter apply to legally established structures, parcels, and uses that have become non-conforming by subsequent law.
Okay, legally
And then
established.
cross out adoption of its title, as well as structures, blah, 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 blah. That takes care of the problem I see. You okay with?
I don't like getting rid of adoption of this title, although I see that you're trying to rope in previous versions.
Right.
By adoption of this title or previous
Subsequent
zoning
law,
codes.
including-
I just, because then when you read it later, it says non-conforming due to subsequent amendments to its
Yeah.
text. So
This title's text.
to this title's text, yeah.
I mean, that's fine.
Yeah, and for that matter, 1721-030A does address what is
Right.
considered to be legally, says any legally established use, structure that is in existence on the effective date of this title or any subsequent amendment, but does not comply with all the standards and requirements.
What about the provisions of this chapter apply to legally established structures, parcels, and uses that have become non-conforming through amendments, through the adoption and amendments of the zoning code, including the current version of this code?
Sure.
Under applicability?
Okay, now I have to remember it, so
Okay.
give me a moment.
I was going to say, I'm willing to leave this up to all of you who know what we're trying to say.
Okay,
That'd be
one,
fine.
one more time, Julie.
I'm gonna try to get it again.
It's gonna go-
The provisions of this chapter apply to legally established structures, parcels, and uses that have become non-conforming through amendments, through adoption of, or amendments to, I should say,
Yes.
or amendments to the zoning code, including the current version of this code.
Okay. Anything on pages 100 and 101?
Well, yes.
Okay, I think he's going to have found some commas and things.
No, this is even more serious.
Okay.
The variance, the word is capitalized.
Oh, right, yes.
You saw that too. Okay.
The red strikeouts, and sometimes I read it and I think, wow, there's words
the
entirely
same
missing,
thing.
but they're there in red. They're the same word repeated again.
Mhm.
So it's hard to keep track, I'm sure, for them. Anything else important? Okay, pages 102 and 103.
Well, 101,
Oh, got one.
I guess we have residential uses and structures in the title of B2. Then we just say non-conforming residential uses. Should we make a reference to structures? Residential uses and structures? I realize the structures are a residential use, but
Yeah,
if we're gonna do it in the title, maybe we should do it.
sure.
2 looks good to me now.
Yeah, add structures before May.
Parking.
Ah, Once again, under section the 020B, we're again relying upon what's in the title for the meaning of the section, which is not consistent with interpretation of the zoning code or just a general interpretation of the Calaveras code. So I think maybe we need to say the following applies to a change in use, expansion of use, etc., in an existing non-residential building. In other words, put what we have in the title into the,
But it's already stated in the statement below the title. Do we
where
have
do you
to-
see non-residential in that statement?
I'd like to draw your attention to 1721-070.
1721?
Yeah, 1721-070, which is on page 101. And I think the section that I was going to refer to would be C. C, where it says absence of permit.
Look, wait a minute, what page?
Page
This is
102,
102.
yeah,
That's
102,
fiction non-conforming use,
Capital-
it's simply the lack of a permit.
capital C above. And I think this section probably tries to, it kind of describes a scenario I mentioned earlier, where it says, if you have a non-conforming, any use that is non-conforming solely by reason of the absence of a permit or approval may be changed to a conforming use by obtaining the appropriate permit and approval. That is easier said than done. Because if you have a building that predates 1960s, the construction of that building to bring something like that up to code, well, first of all, are we going to be looking at that building based on the available code when the structure was built, if you didn't know when the structure was built? Or are we going to say, in order for this building, for the building department to issue a building permit for this building, it has to meet current code standards?
That's a very good question.
It's a very good question.
Actually,
And
it's
Michelle
too
is going
bad
to.
Doug Oliver is not here. Typically, they will often allow you to do it at the time it was built to those codes, but sometimes
We don't know.
so far back
But I
that, yeah.
think this is about how we treat it in the zoning code. I don't
That's
think that's.
exactly.
And I think that what this is, and it's May, and I do think, Mr. Elliott, you're right, in that we might have changed our code so that a use is a prohibited use now. And therefore, they're not gonna be one of those people that might be able to bring it up to code with the correct permit. But if it's still permitted, if there's stuff that they can do, this gives the option of, if that's available to them in the zoning code, they'd be able to.
Well, and it's a non-conforming use, not a non-conforming building. So they have two hurdles, right?
We don't even need this. They can read the zoning code and get a sense of what they need to do to bring their non-conforming use up to.
And it's only saying you can fix it if it's only a lack of a permit.
Yeah.
This is what you can do. You can
Right.
take care of it. You don't have
But
to
if
do
you think
anything
it
else.
makes it more confusing, I think they could read the zoning code and figure.
But what are we requiring them to do? I mean, it's
We're just saying that
Yeah.
if something is a non-conforming use, that doesn't prohibit them from doing what other people have to do to create a conforming use. So if a use exists right now, because it was legal at the time it was established, and now it's a prohibited use in the zone with a change in this title, for example, they if now, let's say it's a conditional use and it was a permitted use before, if they don't like the idea of having a legal non-conforming use on their property, they can do what other people would have to do. They can get a CUP and render it conforming.
Okay.
No, no, but
I think
that's
we're-
not what this section is addressing.
Yeah,
though.
but let me throw in something.
Yeah.
I think we get confused with the word non-conforming. There's non-conforming, but okay. And there's non-conforming. I mean, you're not up to snuff. You know, are we talking here in this provision, are we talking about non-conforming, which I think Julie was just mentioning too, you know, the right non-conforming. I'm not up to current permits, but I'd like to be. But I don't have to do anything because I'm non-conforming under the definition
I
of the
can
statute.
answer what this is addressing, though. It's because if you have a legal non-conforming use, you
Yes.
can't expand that use, but you want to expand it. But the only reason it's a legal non-conforming use is because you never bothered to get some particular permit for it. Well, then you can go back and get that permit and then be allowed to go forward with all the rights and responsibilities of anybody else with a conforming use.
That's another reason we have an architect on the planning commission.
Yeah.
I
Thank
mean,
you,
we
Doc.
could modify, we could distinguish by every time we say non-conforming, but we mean legal non-conforming, we could add
Said legal.
legal and then shorten it to LCU and then put LCU all throughout there.
But
I mean,
that's still,
yeah. I mean,
that's still, so that still doesn't address the question as to whether or not, if you say go and get a building permit, are you going to subject them to existing rules and regulations? Or, so let's say you have a motel that was somehow built and, nobody can find permits for it. And you say, go get a permit for the motel. So is the building department going to say, you have a motel, we don't know when it was built, therefore go? Or are they going to say, you need to have fire sprinklers and all those safety issues that are required for that type of
If
occupancy?
it was built without permits during a period of time when we permitted structures, then it's not legal non-conforming, it's just
an unlawful
it's an
structure.
unlawful
And I
structure.
also don't think we're intending to affect, in this
No.
section, I don't think we're intending here to speak at all to what the
Well,
building code
Exactly.
requires.
So we totally get it, but I'm just giving you the reality. When you say go and get a permit, who are you
Yeah.
getting the permit from?
Well, it could mean
It would
a
mean-
building permit, it
could
could
mean a
mean a
building.
conditional use permit, it
be a
could mean
building
an
permit. If it's a
AUP.
building permit,
But one
definitely a
would-
building gets into the picture.
This is talking about non-conforming things that are non-conforming to the requirements of the zoning
Yes.
code.
Yes,
Right.
that's my understanding.
So the absence of a permit that this is talking about refers to a conditional use permit?
A
And
description-
Or an AUP, so saying there's a,
Zoning code.
Okay, so it doesn't apply to a building permit.
I don't think.
Correct.
It could apply if
Well-
but it wouldn't be a legal non-conforming structure then. It
But-
would be just a,
I think we're
Because we-
confusing ourselves by trying to involve the building
Well,
requirements in this
okay,
section.
because I think that needs
It's
to
a
be
question of-
clarified though, because we make that determination on a regular basis.
Yep.
It's not uncommon for us to get a phone call from a lender or a real estate agent saying, we've got this property in escrow and there's this structure, there's multiple houses on this property and, we don't know when they were built. What is the status? Can they rebuild these things if they were to burn down? Or can one of them, be expanded? We get these questions all the time and so we
but
have
Gina,
to.
you're not making, even in that, you're not making a distinction of what the building code would require.
No,
You're letting them know could it be rebuilt under
Right.
this title.
right.
So I think we're just confusing it by bringing what would building require? That's not this section.
No.
When planning is asked to determine if something
That's-
is legal non-conforming.
Right.
What we're looking at
Is-
is under Title 17, is the use allowed in that zone?
Right.
Okay, is the
Does
structure
it meet
allowed?
setbacks?
Does
Does
it
it
meet
meet the
setbacks?
height?
Right,
Right.
and then,
But we get calls like, can I add another house on this property?
And so you
And,
get- so-
and so we have to go through that exercise of determining whether or not structures are, where they fall. Are they legally non-conforming parcels?
But you wouldn't
When,
look to-
when were they established? We don't get into
Look,
building
look,
code
look,
requirements.
But Gina is making a very good point. This, from a standpoint of a practitioner, people who are at the counter dealing with this kind of issue, when you tell somebody to go and get a permit, it's got multiple implications.
Right.
It means, okay,
One of
so
them is building.
one of them is
so
building.
we just need to clarify through the use of forms or a caveat on the form that we are only answering questions that are within the purview of the planning department.
Right.
Which we only
And,
do.
and we can put something that says, FYI, be aware that there might be additional requirements under the building code. To answer those questions, you would need to go to the chief building official. But for drafting purposes, it's such a typical, the whole determination of whether something is a non-conforming use is a term of art in land use, and it's always related to the zoning code in every county that uses that term. So I completely agree with Martha at this point, that I understand people might be confused by thinking that somehow if it's a legal non-conforming use, they might think that means they don't need to do something someplace else, but they might need a septic system. They may need, there's a lot of other, we could just have a general blanket warning on our website or application forms that permission through this department is not the same as permission through other.
Then I think we need to change the language in here. Because any use that is non-conforming solely by reason of the absence of a permit, planning doesn't issue a permit.
It does.
Okay, what if we just,
Conditional use
Conditional
permits.
use permit.
what if it's just the
In
absence
this
of,
particular instance, when we're talking about a building or a structure, planning doesn't issue permits for
It's not
buildings and
saying anything
structures.
about a building or structure, it's saying a
Use.
use that is
Any use is
non-conforming.
We
non-conforming.
are talking about illegal nonconformity here, aren't we?
We're
No.
talking legal.
no.
No,
We are talking only about.
we're not talking
legal-
about unlawful.
Right.
Okay.
We're never
So
talking about,
back to
in
your-
this section, we're not talking about illegal things. We're only talking about things that were
Use.
legally established. Because that's by definition what a non-conforming
Right.
is.
Okay,
So.
this chapter,
Gabriel does want some clarification. We could simply in this sentence say, by reason of absence of a permit or approval required by this title.
right, because the entire, this chapter deals with non-conforming uses, structures, and parcels. So by definition, there are implications in here that we're also dealing with not only buildings and uses, but we're also dealing with structures. So when you have an absence of a permit, and I don't know too many people who think that when I say permit, we're talking about CUP. This, to me, as a planner for many, many years, implies some kind of a document that says that your structure is legal and was approved.
But doesn't what Martha just suggested?
I
wouldn't
think-
that
Yeah, I
language
mean,
take
yeah, she
care of it?
provides-
That would take
provides
care
the
of it.
clarification.
That
I'm
would
fine
take-
with.
Well, we need to provide
I
a
think that's a
clarification
good
of
edit that
what.
Martha suggested.
Right, it's a good edit. I totally agree. But just to leave it this way and
Oh,
say
no,
that.
you're right.
And say that we are conflagrating issues with building permits, it's not sufficient.
Yeah, okay. Anyhow, Martha you must got it, because you
Okay.
had it.
Got it.
Let's talk parking. The favorite topic of every planner.
I also have Tim's
Okay,
edit
Great.
got back too.
Yeah, I mean, you've come up with the edit, but I came up with the gripe, that's fine. Oh, then under alterations that increase the number of dwelling units. Creation of additional dwelling units through the alteration of an existing building or construction of additional structure or structures requires parking, serve the new dwelling units. It just seems to me that it does not take into account later provisions about accessory dwelling units.
Yes, because they have their own very special requirements, as
Yeah.
Doug spoke to this morning.
Well, they have their own special, but I mean.
Right.
But you can have, you don't have to have.
And they
Well,
don't
this
count
is-
as additional dwelling units under the zoning code anyway, because they
Right.
don't increase density.
Right.
It's just a whole quagmire.
Well, then do we start this with like subject to section 17.25.040 or disregarding section such and such?
I think that the state keeps changing this. I think that it would be easier for you guys to just assume that when we get more granular with special types of housing, that we'll just update those as needed. I mean, to draft around all of the exceptions that exist for housing.
Yeah, this kind of catches
Yeah.
it all,
This is
so-
the general.
This is the concept.
Right.
And it's modified by things that the state has imposed on us.
Subject to other something. I mean, we should have something in here. This is one of the clearest statements in the zoning code. And it
Well,
doesn't
so
apply.
this is just, so you have to provide parking for those new dwelling units. If that new dwelling unit is an ADU and no parking spaces are required, you don't have to provide any.
No, I know
If
that.
that new dwelling unit is a multifamily unit, then you have to provide one if it's a studio. So this is the general, whatever that new dwelling unit is, you have to provide what's required for it.
Yeah.
And if
that
the
isn't
requirement is
thing.
nothing, then it's
It
nothing.
might be zero, right?
I don't, when we have a very clear, all-encompassing statement that there are exceptions to, I think we ought to have something like subject to other provisions of this
In
code.
the applicability section, we should be covering all of these things that you want to add to each section by just saying, to the extent it's preempted by state law, it doesn't apply. This doesn't apply. I mean, I think an applicability section in the beginning would take care of all of these.
Well, it's not just, I mean, it's other provisions in the zoning code that are reflecting the state requirement.
I just am concerned about trying to, if we try, we'll never be able to draft around all of the.
Well, that's what I'm
Exception.
suggesting, a more, a general exception, subject to,
But wouldn't that just be in the applicability
I
section
think
for
the
the
first
title?
sentence under applicability would be where you would do that.
Or just for the?
Well, we also have that, don't forget, in the general introductory to the entire code. Like, so it's how many times do you want to say that?
Right.
so what's suggested?
Would leave it
I
as
would leave it
drafted.
as is, because as you read through to look at your specific situation, you will only be happy to find out that perhaps there is an exception that helps you, and that's true.
It's like a bonus
throughout
at the
any
end.
code. There's a blanket statement, and then there are exceptions that
Right.
you
Yeah,
dig for.
But usually those say subject to or with the exception
No,
of.
not typically, in my world.
Okay.
This is a fraught area because the state is continually trying to eliminate parking, which in ways that make perfect sense in more urban or suburban areas and which are completely unworkable here.
Well, then we don't need to get technical. We can just say, creation of additional dwelling units through the alteration of existing building or construction of an additional structure or structure requires parking to serve the new dwelling units unless it doesn't. I mean, that's what you're saying. I mean, what's the point of this?
Well, it's a continually shifting thing.
Yeah, well, I mean, anyhow, troubles me.
Well, if ADUs are your concern, they don't count as dwelling units.
I know. but I'm getting back to user-friendly, somebody,
I know.
Then you're gonna go, okay, well, how many parking spaces do I actually need for this extended use, right? And you're gonna go to the table and you're gonna see that ADUs do not require parking.
I mean, you could say after dwelling units,
okay.
certain, unless exempted by other portions of this code.
That's what I was,
In the short, just a shorter version, no, without.
But it
all
could
the-
be exempted by state laws too, and we haven't caught the code.
Right.
well, I mean, why not refer to the table?
Yeah,
like-
And it just did.
Yeah, but like Julie just noted, there might be changes in state law that don't get codified in code, and then you're kind of finding yourself in that,
which we already have been
Right.
dealing with for the last few years.
right. We're playing catch up right now.
And it's shocking to me as I read through the new state stuff all the time. Like, wow, when did that happen?
I think we're gonna have a very generic thing, except when otherwise required or something like that. And then have this general statement. We don't have to cite to every section that would give an exception. We have, unless otherwise required at the very beginning, and then a citation to the C table 17.22.040.
I'd be okay with that. I'd rather reference into our own document than to state law, which
Oh, yeah.
people won't know where to go
no,
looking
no,
for
no.
it.
No.
So I would be fine with that. And
So you want to add at the beginning
At
of
the
this
beginning.
statement,
Unless otherwise required.
unless otherwise required?
Yeah, and then
is it required or unless otherwise
Specified.
exempt?
I was gonna say, the required
unless
is not the
otherwise
right word.
specified, how's that?
Specified, okay.
Yeah, that's fine.
And then after the end, have a C table 17.22.040.
All right. And we have the same exact issue when you look at existing parking to
Yeah.
be maintained.
Yeah,
Because there's some cases where you
Right.
don't have to maintain it.
right.
So maybe we would make the same
thing.
modification unless otherwise specified, no.
Yeah, yeah, that's great.
Well, I mean, the one thing I like about this section, though, is that it is not telling us to prohibit a particular use because there's no parking for it if it's an existing use that was developed without adequate parking or somehow the parking went away. At least this code is not telling us that you can't allow new uses on that same site. So that's a good thing. That's progress.
Right, the non-conforming
They're not
parking.
informing, yeah.
And some of the exceptions and interpretations that allow a minor increase without needing new parking are
Yeah.
improvements.
I mean, we struggled with an example. There was a property in Valley Springs. Remember that one, Gina, on Highway 12? Across from the historic train station.
Oh,
Yes, that one. I mean, how the use got there, we don't know, but zero parking, but it's being used.
Yeah.
And we had a change, some kind of a change in occupancy type or whatever.
they wanted to add, the building previously was a, long time ago, probably back in the 18, maybe as early as the 1800s, was a hotel. of some sort, a bar and a hotel.
With no parking.
It had maintained some sort of a use at one time, but it subsequently went away. For a long time, it went away, and they wanted to reinstate some sort of a use in the second floor.
Well,
And we struggled with the parking situation because there literally was no parking. The property, the building itself was property line to property line. There was a little bit of space in the back, but they couldn't even get there because they didn't have direct access.
Would
It
that be
was
an
a mess, but we
abandoned
made it, we made it work.
That would be an abandoned.
Right,
use,
but you
wouldn't it?
can't make the building
but it's being
unusable
used.
for
Right.
anything.
Right,
Yeah, but it's being used though.
Are we really dealing
Condemn the
with
building.
so,
030B
So those are
here?
kind of
oh,
legal
30,
nuances that
the
we
non-conforming
have to
parking,
deal with.
Yeah,
existing use
Now,
of structures.
and there's a use of non-conforming that I think we meant unlawful. An existing use of land or structure shall not be deemed to be non-conforming solely because of a lack of currently existing parking facilities.
Right,
Isn't that,
Yeah.
don't we mean unlawful,
no,
unlawfully?
uh-uh.
No, I think it's.
Well, it shall not be deemed to be non-conforming. I mean, non-conforming is a good thing for the property owner, correct?
Right. So we can't deem it.
So in other words, it
non-conforming solely
conforms.
because of parking.
So we're saying, we're not gonna say you're non-conforming, you conform.
Yeah,
You
so,
are
Oh.
conforming.
So it's legal. It's,
Their
Right.
use is still conforming, they just don't have sufficient parking.
Right.
We're gonna say that's fine, because it's
Right, we're
existing.
saying the parking is okay.
yeah.
Which means that they won't be subject to,
Yeah, in the margin, I put meaning, question mark, still existing lawful use, I mean, really, we're talking about a lawful use of a land or structure shall not be deemed to be non-conforming, so does that mean it will deem to be consistent with this title as enacted?
as long as the use is conforming.
Right. So we have that same building with no parking. It's a bar in a C2 zone that's been used as a bar and a restaurant. It completely conforms to the zoning, but there's no parking on site. So we're not gonna call the whole entire use non-conforming just because they don't have any parking,
Or the building for that matter.
right?
I mean, which.
Okay, so it's whatever parking they have is gonna be okay.
Yeah.
Right.
Okay, can
It
we,
is what it is.
There it is. It is what it is.
would it,
And I think we find a lot of that in Calaveras County, you know?
okay, would it make it clearer if we said an existing lawful use of land or structure? Because that's, I guess that's really the question we're dealing with here, is whether it is a lawful use.
I think it's fine how it is.
It really is
It
fine
doesn't-
how it is?
Yeah, I don't know, it doesn't.
Yeah.
I think we're just
confuse-
Okay,
gonna further
never mind.
complicate
I
and
got-
confuse the issue.
I'm not confused and I'm easily
I'm
confused.
done, I'm good. Okay, that's great.
No other changes on 105?
Not for me.
106, 107?
106, should we have provision, commercial uses, under commercial uses, personal storage facilities?
Personal storage facility?
Well, and back in the,
Mini storages.
yeah,
They don't-
that's what I understand is meant, under the, classifications.
We don't currently require parking for, if there's an office associated, there'll be
Office.
parking associated with the square footage of the office, but we don't require parking, at least not now, for the mini storage itself.
Okay,
Because they park in front of their.
People will, yeah, it's not
I see, so there's no.
common for people to like park in a parking lot somewhere and then walk to their unit.
I-
So we require a, you know,
Okay.
proper distance in between the units for vehicles to pass each other, presuming that everyone will pull up.
But we do have the requirement that there be enough
Yeah,
width to take care of that.
right.
Okay,
Those standards are rolled in. It's 25 feet.
okay.
It's been a long time since we've seen one of those.
A mini storage?
Yeah, to come to us. at the Planning Commission. There are plenty of them out there.
I think people are finding,
We had
Went a
one,
couple
we had
years
one
ago, yeah.
that Catherine brought forward in, it was in
Copperopolis?
Copperopolis.
yeah, yeah. You have another one coming up. It was a previously approved permit and they let it expire, so they had to reapply. Yeah.
Okay, so 107,
So,
nope. 108, 109. Oh, yeah.
yeah.
So the parking in lieu fees.
Mm-hmm.
Oh, yeah. I see.
108 at the bottom, the in lieu amount. So depending on what happens with Murphy's, there could be future in lieu
Right.
programs. I think we would want to make sure that we don't limit the way that in lieu fee could work, because I would think in the future, we might want to consider annual payments or something other than a one-time
Yeah.
buying a parking space.
Yeah, and I think that's kind of, that is a bigger discussion that the board needs to take into consideration, because I think you're right, you know. I think the way we've traditionally done, you know, managed that particular program doesn't really work. Because you end up having to wait for development in order to gather enough money to go do something, and then if you don't get any development that is putting into that, then you have just this small amount of money sitting in this account that you can't do anything with until you get more cash. So yeah, it kind of doesn't really work. I mean, I think it did for a while, but it's kind of dried up at this point.
All I'm concerned about is that we just not hamstring ourselves in any way
Right,
about what that program might look like.
Right,
in the
no.
future.
and that's why we tried to keep it kind of generic.
What is it for
Right.
parking?
Yeah, that's,
It says
So-
just fee, so.
Yeah.
What-
So right now, there is a resolution approved, multiple resolutions actually, approved for the community of Murphy's. And the intent is to allow a mechanism for developers of smaller, generally speaking, it's a historical site,
downtown.
right? It's downtown historic Murphy's. You don't have any parking, the parcels are small. Somebody wants to either build or rebuild or some sort of development that requires additional parking. Well, they just don't have the space. So it allows them the opportunity to put money into a fund. In lieu of parking, they put money into a fund. The money is held in a fund by the county. And then the intent was to actually provide public parking. So there was, I believe, 2, maybe 3, correct me if I'm wrong, where 3 different times, I think, where the county had enough funds to go and build a public parking lot that served that general area.
And they never built any parking lots with the funds.
I-
They leased parking,
Well,
then those
I
leases
believe
expired.
the leases expired, which I think they should have, but I believe we had made the improvements, but
We made improvements.
we made the
to lease
improvements, but we
property.
didn't obtain the property.
Right.
And so then as a result of those expired leases, the property has now sold and we know. So I don't know whether or not they're still able to use those, but
Right,
Yeah.
so anyway.
so it needs, the
it's
program, if it's gonna,
purpose.
if it's gonna keep in place, then it probably needs some modification. Whatever the board wants that to look like, I don't know. So we're just kind of keeping general language in as a placeholder because it's already in code and we currently have resolutions established. So with that, we're just, like I said, just kind of keeping it very general.
Okay, thanks.
And by saying within the district, it's just the district in which this fee applies.
Right, with the understanding that there may be more in the future. I mean, if the county sees this as a benefit, they might want to actually establish future districts that would allow for the same opportunity in other areas of the
And more
communities.
importantly, we have to make sure that we collect those fees when applicable. I
Right.
think part of the problem is that even though we have that standard in the code, those fees are not always collected.
Right.
Yeah.
Well, because it's tough, because some of the way we interpret a change of
Right,
use in
right.
those historic downtown
Right.
areas, and that is going to continue, so it will continue to be a challenge.
Yeah.
Anyway, should we talk about other parking issues? Do you guys have anything else? I have a question in the parking design standards. So we struck out under page 109, under access control, we struck out where it says parking areas shall have adequate barriers, directional signs, curbs, or other control features to limit access to the approved encroachments from the paved parking area. I don't understand why we took that out, but I'm pretty sure.
There was a lot of discussion. The statement seemed to be confusing. Yes, Martha?
Yeah.
And I think that, didn't you run this past, whoever reviews this and they suggested taking that out? Because we asked for clarification on it and you said, just take it out.
Then my,
Do you think I ran that past Robert?
you did
I think he
run
was
these
here.
past Robert and he did look at them. And
Because we asked for clarification of
Yeah.
what this actually is, and he said, just take it out, it doesn't.
I honestly don't remember who I spoke with. I was thinking that it was
Robert.
here, but maybe it was Robert. But I just vaguely recall there being a lot of confusion with that statement that we had made, so.
So Madam Chair, are you suggesting?
Are you
that
suggesting we put it back?
you
Yes,
want-
because we don't want people just pulling out randomly
Right.
across the sidewalk from a parking
Okay.
lot.
Well, do you want to maybe then just say in compliance with, I don't know, I think he might have wanted that out so that we could defer to
Something else.
something else that's in their standards. So if we can put
But
it
they
back-
don't control
They don't
parking
actually
lots.
do the parking
No.
lot check.
They don't.
Planning.
They
does.
handle the encroachments onto county maintained roads, and beyond that, and the grading, it's all us.
Okay.
Yeah, so maybe it could be simplified. I think he doesn't want us stepping on his encroachments. I'm totally good with that. So maybe it should say that encroachments are permitted through the Public Works Department. But I think we could still say that the parking areas shall direct access to the approved encroachments. I don't think we need to talk about all the things you're going to use to do that. It would depend on the parking area. The other thing was, we don't want people just backing out into the street from parking
Right,
area.
right.
So that's why we use landscaping and curb stops. Now, I didn't have a problem with the previous wording. But if we're concerned about Public Works, I think we could clarify that the encroachments are actually permitted through Public Works.
Do you think you want to say control access instead of limit access? I don't know if that was part of the concern, because an encroachment permit by definition is allowing access to something. I'm just trying to guess at what he might have been concerned about. And maybe he was worried about the use of the word limit. I don't know. I'm just grasping at straws.
Yeah, I think it could have other wording.
Could be the limit access is the problem.
I would take out control probably and say, or other features to direct access to the,
Yeah.
control sounds like it might be arms and, mechanical features.
To direct access.
This is probably a policy question for the planning commission. What is, I'm looking down at bumper guards and wheel stops. What is your perspective on requiring bumper guards and wheel stops? And I say that because at the government center, they make it a point to have wheel stops and bumper guards, and but not only that, to paint them in a particular color. So we're giving a developer the option of putting in bumper guards or wheel stops. I mean, do we want them or do we not want them? Are we saying it's optional? And there are pros and cons. I mean, the pros, everybody knows it keeps your, vehicle from encroaching into a landscape
Onto
area
the
or the
sidewalk.
sensitive parts.
The
But
sidewalk is the most
the
important one, I
cons
think.
have been that people who trip over them, it's become a kind of a legal snafu. So I would prefer that we took a position one way or the other, rather than leaving it to the pleasure of a developer. Because if we want them in our code, we should say we want them, but we don't want them in places where they would, for whatever reason. So.
I think it depends where you are. If you're up where you need snow removal, you try not to have wheel stops and you use a curb that's inset so that the front of the car hangs over the landscape area, because you don't want something that's going to be an impediment to snow removal. But in other places, it's much less expensive to put in wheel stops. And so that makes sense. And they're required. You have to have that wheel stop on an accessible space to stop it from encroaching into the walkway in front. I think leaving it up to the developer, because the layout's going to be reviewed by the planning department.
Right.
So
decide whether it's appropriate.
maybe I'm misreading this. So is the option for bumper guard or wheel stops? Is that the option? You can choose between one or
I
the
would say
other, or
curbs.
is the option is whether you want bumper guards or wheel stops, or you don't
Or nothing.
want either of them.
What are bumper guards?
So
aren't they
bumper
the
guards are usually, I don't know what, in my world, a
Yeah.
bumper guard is something that, because when people back in, they run into the wall or the fence or whatever. And you actually want to stop the bumper from hitting something.
Okay.
And
So they
a
could
wheel
be
stop
bumpers.
is the
Yeah.
precast
Figured that.
thing. But it should also say or curbs, because curbs are the alternative of just like a continuous wheel stop
Yeah.
against a
Yeah.
landscape area.
Can't a wheel stop mean, can't that like encumber anything that stops?
It could, but it
wheel.
typically means that
Okay.
precast 42-inch long.
Uh-huh, thing that's
Yeah.
bolted into the
Concrete.
ground, yeah.
But it could be a wood wheel stop. I mean,
Sure.
there are, but I would just say curbs, bumper guards, or wheel stops could be used. And I don't think I would tell them whether they can use them or not. I think it depends on the situation and which one's most appropriate.
Mhm.
And do we want and or? I mean,
Yeah, and or is fine.
okay,
Because you could have a combination.
well, yeah,
The biggest issue I hear from clients is that trucks would like to back into
Yeah.
spaces and then they're hang over much further than the
Right,
front
right.
And I also hear
from the
that
neighbor's
they,
property.
I also hear that they retain debris, so between the curb and the bumper stop is that dead zone where things just kind of gather. And it's a debris and then it's a trip hazard. So those are the things that I've heard, why they don't want those things there. But again,
They are a tripping hazard.
we are there, but we have them
Yeah.
here on our on our campus, and we're required to have them. So if we have to have them,
Well, and I think it's necessary to maintain the proper distance on your sidewalk for pedestrian, path.
And I think in areas of
travel.
snow, I mean, requiring
Right.
alternatives, yeah, that could be an alternative to a wool stuff in a few snow areas.
I don't have any big angst over it.
Okay.
I think you have to trust that people are gonna do what works in their parking lot.
Yeah, exactly.
And that you'll be able to weigh in on it.
You're gonna likely do it cost less.
Yeah, so we're requiring them, we're just giving them the option to choose between.
No,
one
we're
and the other.
not. We say they may be installed with
Right.
the option
Okay,
of
so we're
the
not
developer.
requiring them.
No,
Yeah.
we're saying it's an option.
Okay, that's what I wanted to know.
If it's necessary, go ahead and do it.
I'm okay through 112.
Moving on to 110. 111.
Yeah.
112.
So on alternative parking area designs, I think you're talking about paving, right?
Where are you?
112
On 112,
Oh,
L.
subdivision.
oh,
I,
I.
Capital I.
yeah, capital I with a dot. That means that's a period. Alternative parking area designs. So generally, that's a paving alternative that's being described. I don't know if you wanted to say alternative paving
Mm-hmm.
sections, or if you want to leave it generic and possibly something else will come up that somebody has a brilliant idea for.
I like that.
Leave it generic.
Yeah, the covered statement.
All right. Perhaps under paving then, under F, we want to kind of say alternative paving designs may be considered. I mean, it says, or equivalent. So maybe that handles it.
Equivalent, durable and dust-free surface. So it has to be equivalent to 2 inches of asphalt concrete.
I'll leave that with not super important.
Okay.
If somebody wanted to have something, the surface be something that wasn't equivalent to asphalt concrete, but would then,
It's like
subdivision.
equivalent in what way, right?
Yeah.
Yes.
and would I apply, and they want to have a grass parking lot.
Well, you do the grass parking lots, you
Well,
have these
there are-
precast
Blocks.
There are
concrete
grass
blocks and
pavers.
they grow in, they
Yeah.
make some polymer ones, there's a
That
lot
would-
of different things.
That would be
So
an alternative parking.
See, there's
Right.
lots of
the
alternatives.
area
Lots of
design
stuff.
sounds like you're talking about the layout of the parking area, and I just want to make sure that that applies to
Yeah.
the paving. So as long as you guys make that clear, I'm
Okay.
happy with it. I don't think there's anything to talk about on post-disaster recovery, right? And then we have signs. And,
And it's 5 minutes after 2
Yeah.
o'clock.
okay, so you probably need to leave.
Yes.
Can we, do we think we could make it
Go on for the
through
next
signage,
hour?
or should we wait and take that up
Well,
next
I
time?
think we should ask Gabriel if he.
Yeah.
I think signs is probably take a fresh
eye to review that, because there's quite a few things in here that's, it's going to elicit some additional discussions. But that's just my opinion.
I felt like they captured most everything. I
Yeah.
have only a few
I-
relatively minor things.
Me too. So it's just a question of whether you think you should be around to cover signs.
Do you want me to share with you the changes that we propose from this point till we quit today?
Yeah,
And then if you have any concerns about that, we can roll that back around.
sure.
If we don't do it tomorrow, then, and this might be an appropriate time, Wednesday, next Wednesday, Martha is not available. I had a prior appointment that I was not really in favor of moving, but I could, but being that she's unavailable and I have a prior appointment that I made like over 3 months ago, we're not,
That's,
I'm thinking of not having the meeting next week, so I mean, that's one day that's gonna be a less
that
day,
sounds good to me.
fewer day for us to
No
review.
matter what the board might have said yesterday.
So yeah, if you guys feel comfortable with moving forward, at least we can get, some more review in for the next hour.
Yeah.
And then I can take that back and share that with Gabriel. We can have a discussion about it.
Okay.
And if there's anything that we've got concerns about, then we'll bring that back at the next meeting and
Okay,
have a discussion all over again.
Correct. Let's just, I'm suspecting we're not going to have that much here,
Yeah.
so. Okay.
no, I think here, Gina and Martha have been very responsive to what we discussed before, and I'm,
Did we get it right?
yeah.
I don't have anything all the way up until 119.
It's a new record.
And it's a really easy one.
Do you have anything prior to 119? No, we can skip right ahead then?
So on 119, under required permits, and this is actually a global comment, we should check to make sure anytime we talk about uniform codes that we change them to the California version.
Oh.
Or say uniform codes as modified and adopted by California.
So instead of uniform, if we call them California building codes, that's,
Yeah, I don't
Okay.
know what California calls the sign code. It's probably the California sign code, but I would just, you could even say the uniform codes as amended and adopted by the state of California.
Okay.
That's good. Have a nice meeting.
Yeah. Thank you. See you tomorrow.
Yeah.
And then I don't have anything more till 123.
Okay.
And that basically is coordinated with the lighting change. But then I have entrance signs. So non-residential developments,
Where are you?
123,
Okay, yeah, yeah.
under entrance signs. It says non-residential developments with 2 or more tenants may erect 250 square feet. I think 2 or more tenants and they get to have a big sign. So, or more I get. I just wondered if 2 was the right number. I don't feel strongly about it. I just wondered if anybody else had any thoughts on that.
These are basically signs that saying Sleepy Hollow, enter here.
No. Yeah, right. Yes.
It's commercial, right?
Yeah.
Kids
No,
for
that's-
to coordinate their advertising
The
site.
ultimate sleep. That's Sleepy Hollow.
Yeah, your entrance sign would typically tell you what tenants are in the complex.
Exactly. It seemed like for two
Yeah.
of them, do you really
Oh.
need a, you know, I can see when you have, there's people that you can't see on the frontage, and so you have a sign that lists 4 or 5 different people, but
Well, maybe there will be more to come. Just starts with 2.
yeah, we don't know if it could be divided up into smaller areas.
Right.
You don't really know, so maybe that's just fine how it is.
I mean, it does say and residential subdivision.
Right.
Okay.
Residential subdivisions have big
Yeah,
entrances.
that's right.
Sleepy Hollow.
I mean, it's-
Yeah.
yes.
Welcome to Sleepy
Not
Hollow.
Did you all read that Washington Irving story?
Well, actually,
It's really funny.
there's
Okay.
an old development in Orinda that's Sleepy Hollow. How about design for 2 or more tenants?
I'm fine with just letting go of it unless somebody feels, I don't feel strongly about it. I just thought 2 seemed like not enough to actually be a development.
Yeah, but what about the illumination?
Well, we're gonna come back to it when we look at the lighting, right?
Okay, well,
It sounds like he wants to talk about it now.
Yes, it seems okay to me, really. It just, will we do something in that dark sky section that would impact this?
yeah, well, it doesn't have anything about not being directed up.
Well, it does
It
not
just-
shine or glare, yeah.
I actually just realized I have or need to bring something up when you get to it. Sorry.
What is it?
It's the sandwich board changes.
Let's look at them.
It's on page 125.
No, we didn't get that far yet.
We're jumping
I
ahead.
am, I'm just, because I realized.
What, do
I
you
didn't-
have a hot
because
date?
I know, I didn't realize that you had changed it. I should have looked at it against the sign lot. I didn't, so I was like, oh geez, I
Well,
better.
we'll
Let's
talk
get to
about it in a minute.
Yeah. Sorry.
Just be patient, Julie.
So we assume that in the illumination section, maybe we need to direct it to the dark sky or include something that says the same basic comment that it down, fully shielded, blah, blah, blah.
We just add something in here saying lighting, needs to be consistent with and
Yes.
cross-reference that section.
Right.
Yeah, good. I know this is a specific concern of Tom Messino earlier.
Okay, sandwich boards.
I would just cross out promoting goods and services and promoting available goods and services, just because we're not supposed to distinguish between, it's supposed to be time, place, manner, so it's the sandwich board, not what the sandwich board says.
Oh,
Oh, I got it.
Yeah,
Yeah,
I
I thought it
don't-
was just more of a description of what a sandwich board is.
yeah, but that could get us into
Okay.
just illegal or unconstitutional distinguishing between types of.
So we
speech.
can't, so it just has to be sandwich boards may be displayed for a maximum of
Yeah.
14 days without any of that other.
Exactly.
Okay,
and what about other signs? I mean, it's sandwich boards and other signs.
That's okay. It's just
Well,
the one.
and similar signs, because we're,
Yeah.
not
right.
all other signs.
I mean, it's freestanding signs, is that what we want to, how we want to call them?
Another, well, I think they're temporary signs, movable signs.
Well, they're under the temporary section.
I meant I think of freestanding as that stand up on their own, but.
Right,
not
but it
attached.
could just mean that's out in the middle of the parking lot.
Yeah, yeah.
We could call them portable signs.
Yes.
Okay.
So taking out promoting available goods and services.
And just taking out promoting goods and services from the,
Yeah.
from the header too.
This is gonna be a controversial item. If they have to wait 13 weeks in between the use of their sandwich board, because there are some that have been out there for years.
Yeah.
And this is just to get rid of clutter, basically.
Yeah.
Basically, we're gonna have, I mean,
You're
when
never
we
gonna
adopt
enforce
it, there's gonna be a number, like, there's a whole bunch of findings that I think I'm gonna need to draft on, especially on a couple of sections, just to justify the regulations that we have, and that would be uncoded in that codified portions of the ordinance.
And so just for context, this is on your books currently, so you just haven't
Oh, okay.
enforced. Yeah.
It's just, it's never
Of
enforced.
course, I haven't,
Yes.
we'll never find
Well-
findings from the original version to know what's in there or what isn't in there.
That's because we just don't have, well, we don't do proactive enforcement, so unless somebody specifically complains about somebody's sign.
I do suggest the one wording change
Yeah.
in the last line of that subdivision two. Instead of conclusion of the first display, or the conclusion of the previous display. So at least 13 calendar weeks have passed from the conclusion of the previous display.
Unless they only take it out once, maybe.
Right. I think we could probably be a little more generous, but I think we should say something about not block driveways, sidewalks, shop entrances. I mean, that's really the complaints that I hear. Or parking spaces. I mean, people put them everywhere.
Well, when you're talking about downtown Murphy's, you've got no place else to put it but out in the sidewalk
Or in the
or in the
parking
parking
space.
space.
But we should, that's the important stuff, is that it shouldn't be blocking anything.
Right.
So we are outlawing sandwich boards.
No, they'll just, just like now.
Anyway, was there any problem with the previous, my insertion of previous? Because otherwise, why it's 13 calendar weeks from the first display, that could have been 6 months ago. And several display periods.
So we got the word,
Last previous display was really what it should be.
I mean, why are we trying? We know they're not going to do this.
right, well,
So what are we saying?
Not gonna vote?
and I guess we don't have to if we,
I would be more concerned about telling them where they can have them.
because I'm certain that there are businesses that put those out every day.
Yes,
yeah.
there are. And sometimes people put them out on the highway, but then they sometimes disappear. So. I mean, what
So are we
trying
more
to
concerned with
achieve?
the location of the portable sign rather
Which-
than the duration of the
Yeah,
portable
I think
sign?
that's what we're getting around to.
Yeah,
So, I mean, just change the focus of that section. May just be displayed in blue, whatever.
and do we want them to, shouldn't they be located on their own property? And that's not what they want. They want to put them out in the public right of way. That's
Right,
how to
well-
get visibility.
Yeah,
Or down at the corner. So,
and I don't know, is that such a bad thing?
Well, it's a trespass if it's not on their property. I mean,
Right.
technically,
Well-
we can't really just allow.
Unless they've gotten, I
so
mean,
maybe we don't.
then you
say
get
anything.
into the, is this an off-site sign?
Right.
But you know, you've got, well, I'll use this as an example. right here in town on Main Street. There's some signage that's been going up in the grassy area between Goonies Bar and the highway. And it's advertising businesses that are down Main Street that you otherwise, unless you went down there, you wouldn't know they were down there. And so, and I get it, you know, I mean, it's like, it's a new business and they want to bring attention to, hey, I'm down here and I know you're not going to see me if you don't travel down. So I'm going to tell you what's going on. And so
Yeah.
we see a combination of portable signs that are now all over. One's in the sidewalk and the other two are on the grassy area. And they're all advertising things that you don't see from the highway.
So we've tried to encourage in
Yeah.
Murphy's, the businesses to get together and put something up that just is attached to the sidewall of a building and shows everybody that's down back there.
Right.
But those sandwich boards just keep coming
So
because they
I
can't
would-
seem to get together.
So I would say the question of the sandwich boards within the public right-of-way is really a different question. And that should really, Public Works or whoever's issuing encroachment permits should really address that. But regarding on-site sandwich boards and portable signs, what you could do is we can identify a maximum size, a maximum number, a maximum height, and address location. If that seems to make more sense than the days and duration.
Yeah, I don't think we can really enforce the duration. Just because, I mean, it's just, for us, it's just not enforceable.
No.
I mean, it's so widespread and we don't have the
I mean, it
staff.
could be enforced
Hey,
theoretically.
I guess if we had a really super beefed up code compliance department,
Well, and
but
someone to.
we're very limited,
Who's going to track that?
right?
Take a picture of.
Well,
Yeah, but who's going to, what?
how do you know how long that sign has been out there? We don't,
The neighbor will do it if they're upset by it.
yeah.
It seems to me that we're recognizing that if we try to regulate anything but on-site location of these, it's gonna be unsuccessful.
Well, I think we just try to, I think Martha had a good direction there.
Yeah.
Maybe the maximum size of them.
Yeah.
And then limiting the locations that they can go so that they don't impede other people's traffic, you know, walking or driving
Right.
or parking.
Enforce that.
Yeah, even that would be tough, but at
It's
least
gonna be.
it's, I think you
Size is
could
good.
limit the number of them at any particular parcel.
Maybe like 1 per tenant or.
Yeah.
Even that, I mean, there are places in Murphy's where if you let every tenant have one, you wouldn't be able to get back to those tenants.
Or walk on the sidewalk.
Yeah. But then but if you limited it to some reasonable number, like, I don't know, maybe that's gonna even be problematic. It'd
be
on
harder.
the size of the parcel and.
Yeah.
And maybe it's.
Martha, do you think maybe we could maybe do some searches for some other examples?
Yeah, so I guess one question, I just want to tease out the number a little bit because I think that's very tailored. What if it were like a maximum number per lot frontage, square foot of lot frontage? It doesn't sound like you want to just do 1 per parcel or 1 per tenant.
What about size?
Typically like a 6 square feet is generally, I think, the appropriate size, maximum size.
And I'm thinking about Murphy's, which of course has no sidewalk space.
Anyway.
Yeah, as it is.
Well, it wouldn't be a problem, but yeah.
So yeah, that might be the example we go off, because
Yes.
Copperopolis didn't seem to have a big problem. Downtown Angels Camp,
There should just be a big QR code at the entrance, then everybody looks at their phone to find out where the businesses
Yeah.
are.
Well, and I think a lot of these are trying to attract motorists.
And I think your point is good. So the problem of like so many tenants on one parcel is really Murphy's based, which has its own issues. And I do think that should be just addressed somehow within your public right-of-way allowances. But most other areas where you would have these where you can accommodate them on private properties, it does seem like 1 per tenant could work. A maximum of 1 per tenant. Because I think the overcrowding is really a Murphy's issue, which has all kinds of other issues.
Right. And I think a lot of places where they're doing it is where a driveway goes through. And so they're trying to use that space to put a couple things out in it. And there might be, 8 tenants back there. If you everybody got one, it would just block the entire
So,
thing.
I don't know how you could enforce this, but if you actually just put in something that the sandwich boards and other signs shall be placed so as not to unreasonably impede public access to sidewalks and parking areas and et cetera, et cetera, et cetera.
You have to define reasonable.
Well, you don't have to. Reasonable is a term that the courts look at as a reasonable person would do. That at least would give you something to quote to people.
You could also, just say as determined by the planning, as determined by who?
Yeah, well, no, but if you say,
I agree with you on the unreasonable,
Yeah.
There could be a question. I guess this gives an option to code enforcement
Right.
if there's,
that's,
I think what's gonna happen is it's only when somebody complains like, as we're talking
Right.
about the neighbors.
It'll
that-
pass.
Yeah.
oh yeah,
Well,
but then
it's
they have something to point to,
Right.
and then the poor code compliance officer has to decide whether it's reasonable or not.
And then they abate it by taking it down for 2 seconds and putting it back up as soon as.
Yeah, but at least it gives us something that we are dealing with the problem. Otherwise, we're basically saying nothing we do is gonna have any effect.
Sometimes it makes sense to just put it in the code, even if it's not
Right.
necessarily enforceable, so that it doesn't look like we're sanctioning an unsafe
Exactly.
situation.
yeah.
So if we just said, they shall not take a standard size, which is like 20 by 30 or 24 by 36, whatever those real estate signs are, and say that they shall not unreasonably impede access to driveways, entrance to sidewalks, parking areas, or the use of, not just access,
Yeah.
and use of, and leave it at that, and
Yeah, that's what I'd suggest.
whatever Julie thinks we need to do to tweak it to make it, but not say anything about what's on it.
Yeah, we just can't, we can't distinguish between, vote today and
Right.
Bob's fishing gear. You know what I mean?
Yeah.
It's
Yeah.
like,
That's,
The dimensions, now this might be getting too particular, but you're more concerned with the width of a sandwich board than the height. So I mean, if it's 24 by 36, 24 width by 36 height,
right,
then we've got some,
or a maximum width of 24 inches, a maximum height
Yeah.
of whatever
right.
somebody thinks is reasonable.
Well, I think we've got
So-
something we can,
Yeah,
So-
I think that's way better than a timeline that we can't.
So Martha, would those vinyl signs that you can get from the print shop, would that be included in this section as well? It would, wouldn't it?
Those plastic ones that,
No, I'm talking about like the banner style vinyl.
the ugly flags.
No, not the
No.
ugly flags.
no, we know you have a problem.
They're so ugly.
I guess the best example would be, the youth soccer team would parade through the parade with their team and they'd have a banner.
Right.
And it was usually some sort of a vinyl made banner from the print shop and it would be held up by 2 T-posts. This is the kind of thing that I'm starting to see that's why I'm asking, are those considered to be what we were referring to as the other promotional signs?
Because those don't seem portable, really.
Well,
And they are portable.
They are, because you can kind of take them down, and I'm just thinking this might be the argument, you know, you can take them down easily. It's not like they are permanently affixed in the ground. You know, they're in the ground with 2 posts that can easily be removed. It can be rolled up and it can be taken away, which they generally aren't. But I'm just asking because I'm seeing these and I'm reading through our sections and I'm thinking, I just don't see where those particular types of signs might be addressed other than maybe this section, and we're talking about a 6 square foot or, you know, slightly different kind of a.
I've seen them used for most. I mean, I see them people using them as their sign until they get a real sign and they never get a real
Well,
sign.
and that's exactly what it is, but they're off-site. So they're specifically signs advertising a particular business, but because the particular business is not street front or highway frontage, and it's down some little, you know, historic street in town, they're getting permission from property owners that have property on the highway frontage, and they're mounting their vinyl signs on these temporary poles, which is not, I mean, they're not obstructing the sidewalk, they're not out in the road, they're but they're not on the site of the business, so they would technically be considered an off-site sign because they're not what we would consider our typical promotional sign, but it isn't advertising the business. But they could very well fall into this portable sign category because they're not affixed.
What about
Should
just
we have an off-site sign, something? We have never allowed them.
No, but what I'm saying is because of the type of sign, would it easily, am I just like thinking, I'm just trying to think outside the box. I'm thinking that they might be, people might translate those types of signs into this portable sign section, and I'm wondering if you guys see that the same way.
I would just define temporary signs somewhere up front and not include anything where you have to dig a hole in order to put them in.
Right, so we have temporary
Well,
signs
except
where they're allowed, and we don't have anything that kind of encapsulates
I mean,
that.
the real estate signs are stuck in the ground.
To answer Gina's question, I would say if somebody came in today under your current code, that type of sign would be allowed in this section on promotional signs, banners, and sandwich boards, which are all kind of put together. And these are these that can be displayed for a maximum of 14 days and at least 13 calendar weeks are between. So I think as we've gone through and kind of morphed this, I think that kind of moves away from that type of thing, right? So today, yes, if you came in, it would be considered under this, but not kind of as we've morphed it.
Martha, do we use the word promotional in our definition?
In your current one
They took
is
it out
Oh, okay. That's-
Right.
just now.
Okay.
So I think to me, that's the difference, is the word promotional, because these vinyl signs, and I'm not particularly saying I have any issue with these particular signs, they're actually really nice signs, but they are vinyl signs and they are specifically advertising the business, which is not on the site of the sign. So it's technically an off-site sign. But because the sign is portable, meaning it's not permanently affixed, somebody might and if we cannot otherwise, regulate
Why don't we just say sandwich boards and other portable signs, and then just and just include other portable after sandwich boards? And then,
I think Gina's saying that these aren't like,
These,
you don't leave them up forever.
Right.
which is where we're going with
These are
San
supposed to be temporary, and,
Right.
and we're now saying we can't regulate what is advertised or, what's on the sign itself. So knowing that these are signs that are removable, but they're not being removed, and they are specifically advertising, not like a special or, something that is temporarily going on, like a sale or, something in that manner.
You could just say
They are literally advertising the business.
Now, you're saying that if we don't list it, it's prohibited, right? I mean,
Well, we
yeah.
don't allow, we have never allowed
Off-site
off-site
signs.
but that hasn't stopped anyone from having
Right.
them.
So before this, I would
Right.
say that's an off-site sign,
Right,
and it would not be allowed.
right.
But because of the nature of the sign itself and the fact that it is this banner that you can literally pick up and roll up and take away, that it might be considered to be a portable sign. And are we okay with that?
Once you stick it in the ground, to me, it isn't portable.
Yeah.
Okay.
Yeah, I would think that maybe we would have another category here that's like temporary off-site signs, and that might be the right place to use the 14 days and the 3.
Yeah.
Other temporary,
Or other
Or other
temporary signs, yes.
temporary signs.
And then you could say banners, whatever you wanted to call those.
So I wonder if we could amend number 3, which is special
Yeah.
event signs, and if we could include promotions as one of the things that qualifies. Because Gina, I think that's what you're talking about. It's like sign up for soccer,
Well, we have those, but specifically what these signs are is they are advertising a specific business.
But when it's like temporary like that, it's like a certain promotion. So yes, it's a business, but
Yeah.
it's like
Except.
buy a car today, some kind of promotion. So I can amend this to cover that and put a duration in that's not tied if there's no specific event, like.
But I think we want to try to identify the type of sign without
Right.
referring to its content.
We get into the
Right.
problem, we get to special.
And I think we can do that. I feel like we could, instead of saying special event, we could just say temporary signs, signs for special,
I think you could
signs
still
for
have-
temporary events. And we could use promotional, business promotional events as an example, because we have such
Right.
as, we can probably say promotional events and throw it in there as an example. And just not call it, just like, we'll just call it temporary signs. Or, I'm sorry,
We're in temporary signs.
we're in the general section, we could just say other temporary signs.
I think that was my initial thought, and I think that would work. I think that's the easiest thing to do. It still leaves Gina's example
yeah.
as an outlier, but it's always going to be an outlier because it's,
It's really meant to be a permanent sign.
It is a non-residential, it should fall under the non-residential use section under A. Because it should be an on-site sign advertising the business. So
Right.
it says Black Bar Inn.
but except that we're saying that it's temporary, but.
Temporary, just because you can roll it up and take it away.
Right.
Or we could say other temporary signs and then just say no other temporary signage is allowed. I mean, you're saying that they're intended to be permanent is the problem.
Right.
Yeah.
So because they are not on the building of the business and they're out on a grassy area facing the highway on someone else's property, they
don't think
just
you wanna
printed a
allow
vinyl
them.
sign and
But
they.
it says allowed sign, so 1724-100 says allowed signage, and if they don't fit into any of those, can't we just take the position that they're not allowed?
Yes.
Yeah,
And that's what I'm,
But we're never gonna go take them down.
no. But
Unless,
that's what I'm asking is because we're not regulating the content of the sign, could a sign like that be misinterpreted to be a portable sign? And therefore we would allow it just like we would a sandwich board?
But it's not, we don't have a section that says portable signs right now. We
Well,
list
I
off-
thought we had just changed,
we said sandwich and other portable signs.
yeah.
no, we define portable, and sorry, Gina, I misinterpreted what you were trying to accommodate.
Yeah,
So, I think that sign you're talking about is not allowed.
right.
Yeah.
And I would say the same, but I'm saying I'm playing, devil's advocate. So I'm the owner of the sign and you're telling me, oh, I'm in violation by putting this sign up here. Why is this not considered a portable sign?
We can get rid, I think we don't have to say sandwich boards and other portable signs. We can keep it sandwich boards and just, I think we could just cross out promotional. If we're only, I thought initially you were trying to capture it as a type of sandwich board.
No.
And that's why I recommend the change. I think we can just say sandwich boards
And other temporary signs.
and other temporary signs. And then assume that if it's not temporary, it's not.
But then we're gonna have to define what's temporary.
Yeah.
No,
Right.
I think I get it.
Yeah.
I think
Okay.
I get it, and I think there's.
Yeah, and I'm not saying that there's a problem, but I could see that, so there was one sign and now there's two signs and there's a sandwich board.
Right.
And so what is to prevent, three more signs from being put up in the same, and then,
It's where signs go to die.
Well, we can, right? I think Martha could draft it so that we make sure that that's not on the list somewhere.
Do we
Right.
have a base zone that just allows a field of temporary signage?
yeah.
Because they own a parcel.
And I think it would be nicer is if in that situation, they actually put in an actual affixed structure
Right.
and put some sort of advertisement up for people to say, hey, this is what's going on down Main Street.
I actually was wondering if we could make an accommodation for that, a way that you could get a use permit to have signage for off-site.
Well,
Yeah.
isn't that directional signs? I mean,
Well-
what you're just talking about.
That's not really.
Is it really, it's not really direct,
Okay, I'm sorry.
overall purpose of direct sign and inform tourists
Oh, yeah.
and travel, visitors,
Yeah.
various recreation, historic,
Yeah, it
civic,
is
and cultural
commercial.
features.
It's commercial.
It's commercial advertisement is what it
But it
is.
would benefit the community.
Oh, absolutely.
So
Like I said, I mean, these are really, these people are trying to drum up business. They've got new businesses and, and they're good little businesses, but they're stuck way down at the bottom of the hill. And unless you happen to drive down Main Street, you don't know that they're there.
But the function of it is the entrance sign. I mean, it's just the
Right.
entrance sign.
It's functioning as an entrance sign, only we don't have the
Not on
typical, it's not all on one property.
Right, right.
And so it doesn't fit the narrative of our.
San Andreas needs an arch over Highway 49.
I wanted to do that for
Seriously, so that when you're driving down it, historic Main Street down
Yeah,
here.
that's right, including.
Believe me, I've looked into that, because our communities have those. But what if we just said off-site signs and we provided some way for people to get a permit to have
Right.
an off-site sign that served multiple?
Right. And I think that would be beneficial to the businesses. And then they're not faced with having to try to shoe in and kind of, try to wiggle around the code so that they can have this
So
advertisement.
as long as it wasn't limited so again, it could be, a CUP for an off-site sign, again, as long as we're not discriminating between the content. we can
But it
do
would
time
have,
placement.
but it's permanent signage to identify,
Mm-hmm.
Commercial property.
yeah.
And if you do it right,
I mean-
you can switch it out as businesses come and go.
Right, I think if
And,
it
I mean,
only
we can't
could be
get,
tenants, it's not promotional, it's not advertising.
No.
It's just identifies.
this
the
is where we are.
tenants.
Right.
Okay,
And it's, you know,
We
I
do
mean,
that.
we have content and commercial signs
Yeah.
all over,
Yeah.
So
Because
now-
there's a
Before it's
restaurant
here.
down Main Street. Did you know that there's a restaurant that's now open
Yes,
down
I
on Main
know.
Street? Okay,
I did not.
see?
Well, maybe
been one
I
that's open
did.
and closed for a
Isn't
while.
it in Black Bar?
Uh-huh.
Yeah.
Yeah.
Because I read it and I thought,
Yes.
the only place that could possibly.
Is
be
the BBI.
That sounds interesting.
So we could say permanent off-site
Right.
signs and then have a description and that you need to get a permit for it.
Yeah.
And then if you're telling people you can't have all these sandwich boards and temporary signs out here, but you could get together and put in one of these.
Right,
If you get the property owner to agree.
sure.
Right.
What do you think, Martha?
I just, you have directional signs, you have billboards. Now you're also going to have another type of off-site sign.
But it will replace
I mean,
a lot of the little dinky,
So here's my next question. If we allowed that type of sign with the intent that it is going to advertise businesses, could it at some point in the future be like converted to an actual billboard that where they're selling space and now we have this billboard in the middle of town? I mean, because you're right, I hadn't even thought about that. I mean, we do allow,
Are going to be selling space. I think
Yeah.
you could limit the size of it.
You know,
Make it.
I think this is kind of like a separate conversation outside, like, and added into the zoning. I just think there's a lot to kind of think through. There's a lot kind of happening on the fly.
okay. Yeah, we got a little out of control.
We're trying to get rid of all these other
Well-
things that are. Let's just concentrate on getting the sandwich board thing taken
Okay.
care of, leave everything else as it is for now, and we can come back to this
Yeah.
question at some, because a lot of people would have to agree in order to make it work.
Right.
And if
Well-
somebody came to you and said, I want to do this, is there a way we can do it?
And the
We
board
need to
might want
figure
to
out a way.
The board
Yes.
might want to weigh in on the offsite sign.
Oh,
We
yes.
hear a lot about billboards and stuff, so, and it would take careful drafting.
Yeah.
Oh, it would.
So Martha, do you have enough direction on the sandwich board thing to?
I have enough direction on sandwich boards and the special event signs, enough to bring something back that you'll comment on again.
Never a dull moment.
Glad to, yeah.
So I have one other comment in this section. It's 4D. It's the maximum number of signs per parcel frontage. And I wondered if we should have that be an actual frontage length. Because if you were to have a very long frontage, it might make sense to be able to have 2 new development signs on that frontage. Especially if you had 2 ways into the development.
A parcel might be owned by the development
Yeah, it's.
developer and be 500 feet long.
Yeah, that's what I was wondering. So I'm not, Martha probably had something in mind when she said that.
I am thinking this is either your existing code or it's not, doesn't have to be exact. You could say something, a maximum 1 sign per 100 feet of frontage.
Yeah,
Right, because this is residential subdivision, so the parcels have already been divided up. A maximum, well, I'm gonna take it back. I think it's probably fine how, because it's when they're gonna do parcel
okay.
1, 2, 3, 4. That's what,
So leave it as
so
it is.
leave it as is. Worry about it. Okay. Anything else?
So,
Okay, 126. Since we've gotten rid of the stuff down at the bottom of the page, 126, about deemed public nuisance and this sort of thing, do we need, under C2, do we still need to say a sign that constitutes a nuisance to the public, or should we just say a sign that is unsafe as determined? I mean, if something's a public nuisance, there are legal ways of getting rid of it. I was thinking that maybe, why would a sign constitute a public nuisance? Well, that's what was provided before by the parts that were crossed out.
This is to restore a sign that was already non-conforming. If that pre-existing sign constituted a nuisance, maybe because of its location or shape, whatever, then we don't want to allow its restoration. That's what that says. So to the extent it was an unenforced nuisance in some way, shape, or form, it attracted children, but it was dangerous to the kids.
But
I
that's
see.
not what it says. It says a non-conforming sign may be restored if it meets either of the following criteria. A sign that constitutes a nuisance.
Oh, it should.
Yeah, something's backwards here.
That does, a sign that,
If it meets either of it, what I think is, it can be restored if currently it's that's a nuisance or is unsafe. It can be restored. That's what I'm getting from that.
I don't know. I think if somebody's allowed it to become a nuisance or unsafe, it should go away. It shouldn't be restored.
Yeah, I think there's something wrong with that second sentence.
Nuisance is related to the damage, I imagine, correct?
Yeah, we'll look at number 2.
Okay.
Yeah.
Yeah.
Yeah, why would we let a non-conforming sign that's become such a problem and give them
Yeah,
a
something-
chance to fix it?
Yeah.
Yeah, something's off there. So-
generous.
I think we meant to say a non-conforming sign may not be restored unless it meets, it's like less than 50% got burned and it's not a nuisance.
Right,
That's
so
what
we
it
should
meant
just
to
take
say.
2 out, right? And then it already talks about the less than 50% above.
But we don't want to allow that to come back if it was a nuisance. We only want to, if it was legal non-conforming in a way that also was a problem, we don't want to let it come
Right, so we
back.
should just take 2 out, so we don't, because right now we're saying, sure, fix it. You can still have it.
Right.
Yeah, I mean, yeah, I'll look at it.
Look at it. That's great.
Yeah.
Good enough for me.
So this might be a good place to
Yes.
break, being that we only have
We're
5
done.
minutes left in our day.
Yes, I
Standards
think-
for specific uses, we'll pick that up tomorrow after the regular,
I'm assuming there's time.
after
assume there is
the
time.
regular meeting tomorrow.
Yes.
Okay.
Okay, so where is my agenda? Okay, so are there any commissioner reports?
Nope.
Had such a good time, we want to come back and do it again tomorrow. And no planning director reports, so we are adjourned at 5 minutes to 3, and this meeting is already continued to tomorrow after our agendized item.
Okay.
Oh, beautifully phrased.
Thank you, Martha.